on behalf of the University of the Western Cape, the law faculty, CLEAR, Centre for Legal Integration in Africa, the MPL unit of the law faculty situated in the private law department. We would like to extend a hearty welcome to one and all, being our first symposium, inaugural symposium, dealing with the Women's Legal Centre case, where to from here. We have two very distinguished guests. They've been with us before. We have Seehaam Samaai, formerly of the Women's Legal Centre, now a Commissioner, Northern Cape, on gender equality, am I correct?
Yes.
And then we all know our esteemed Shaykh Dawood, Dr Terblanche there. If you don't know, there he is sitting. You can have a good look. So thank you very much for attending. We do apologize for the little delay that we've had. Unfortunately, we had some gremlins creeping to the system, which we just have to sort out. To our attendees here, also, welcome. Thank you for availing yourselves. Thank you for the presentations that you will be delivering. And I look forward to a discussion. Where do we go from here? But before that, I have to also then do the opening. I think that I've been tasked with being one of the members of the Muslim Personal Law Unit that was established in 2023 and officially took off in 2024. Hosting, I think, in 2024, 4 webinars. I'm Samaai of the leadership, the largest part of one. And we are going strong and we're going even further. We're expanding our boundaries, our spheres with IPSA as well, with our discussions that we have, preliminary discussions. So we are pushing those boundaries. And I think being in the Western Cape, we'd like to narrow that gap between UWC as well as IPSA as a joint community-orientated engagement of giving back to the community in more ways than one. Education, spiritual education, everything included in terms of giving back to the community, which I think as we progress, as we become more educated, it's time that we pass on the baton to the next future leaders in whichever capacity they may take or form. Become chefs, judges, attorneys, legal assistants, legal advisors, whichever sphere you go, you have that sense of giving back to the community at the end of the day. Because without the community, we don't have anything. We are just standing all alone. So to educate and to assist them, that's it. Just with giving correct advice and assisting them as far as possible. We do know that the balances are not always equal. And we try and endeavor in the spirit of our God to make sure that everybody has something that they don't know that we can assist them with. So ladies and gentlemen, let me just have my 5 cents of speech I think I should be giving. So as you're well aware, the symposium looks at the Women's Legal Centre Trust case and it poses the question, where to from here? I think it's very apt when one considers that. The discussion about Muslim personal law goes back, I think, in the 70s. There have been discussions. Yes, 70s, early 70s. It then went on to the early 80s. Throughout the 80s, having discussions with the existing government at that time about codification, recognizing Muslim marriages in particular, but also looking at the broader spectrum of Muslim personal law. And then in the 90s, it seemed to have gotten more traction in terms of having some sort of papers that were coming out. We also then had in the 2000s, the South African Law Reform Commission getting involved also, assisting with this particular issue. So the discussion about and the recognition of Muslim personal or marriage in particular, or divorces, it's a discussion that has come on for 3 decades or maybe 4 decades already. It is not a novel discussion. It's a discussion that has been grounded in various terms that have been provided by the ulama, by academics, by scholars, by NGOs that have put this forward. So it's not a new discussion at all. It's not something new. Something that has been there, and it's something that will continue to be there, that will have to be revisited from time to time and re-looked and reshaped, but keeping the essence and never losing the essence of what it is all about at the end of the day. That's the most important thing. So Muslim personal law has come on in time. It's not something new, ladies and gentlemen. So it is against that background that when there is a divorce, which is most detested by Almighty Allah, Prophet said the same, to not play with divorce when I am around, when I'm still here. So it is from that perspective that I would like to then just talk about the following. So in a landmark ruling delivered on the 22nd of June 2022, the Constitutional Court of South Africa, which is the apex court, the highest court in the land dealing with constitutional matters, decisively addressed the enduring injustices tied to the non-recognition of Muslim marriages. The Constitutional Court, declared that key statutes, including the Marriage Act of 1961, the Divorce Act of 1979, as well as the common law definition of marriage, are deemed inconsistent with the Constitution due to their failure to recognize and regulate Muslim marriages, thus violating the rights enshrined in sections 9, 10, 28, and 34 of the Constitution. Recognizing the weight of legislative responsibility, the court suspended its declaration of invalidity for 24 months to afford the executive and parliament sufficient time to enact legislation recognizing Muslim marriages. Pending such legislation, Muslim marriages existing as of the 15th December 2014, or those that were terminated under Sharia, but subject to pending legal proceedings, may be dissolved via the Divorce Act. In such instances, courts must treat these marriages as if they were out of community property, allowing equitable asset distribution under Section 7.3 of the Act. Further interim measures extending the Children's Act and certain provisions of the Recognition of Customary Marriage Act to Muslim marriages to safeguard the rights of children and spouses during this transitional period. So the judgment not only confronts historic systemic neglect, but mandates legislative reform that preserves access to justice and mitigates immediate harm. As emphasized in the judgment, such non-recognition is not isolated, but systemic, affecting millions of people and disproportionately disadvantaging Muslim women and children. This ruling represents a critical turning point in aligning South Africa's legal architecture with its constitutional commitment to human dignity and equality and religious freedom. It also grounds the rights of Muslim spouses and children firmly within the constitutional dispensation, necessitating urgent legislative attention. There have, of course, been a variety of responses from different Muslim organizations, as with all judgments. That's always the case. It seems to be a thing with lawyers. I think they always have to attack something. Don't know why, but they seem to just their prerogative that, you know, whatever judgment, I'm going to attack it, and they go for it. So we've had various different responses from various organizations. Bearing in mind that these organizations were also friends of the court in this application and the amicus curiae. So they were part of the action, as my colleague here will testify to. And the Muslim Judicial Council, the MJC, welcomed the ruling, calling it a significant step toward the full and meaningful legal recognition of Muslim marriages. They affirmed their readiness to engage with government, very importantly, to engage with government, to push it further, to move it away from the legal sphere more to the political sphere now, to enact. So they were looking at that already. So, step towards full and meaningful legal recognition of Muslim marriages. They affirmed their readiness to engage with the government structures during the 24-month legislative window that was provided by the Apex Court. Importantly, the MJC emphasized that the consequences of Muslim marriages should be governed by Islamic law, not secular alternatives, consistent with religious autonomy and constitutional pluralism. Another organization, the United Ulama Council of South Africa, UXA, also appearing as a friend in this particular matter, argued that the Constitution, in terms of Section 7, subsection 2, Section 15, subsection 3, requires legislation recognizing Muslim marriages as a standalone institution or institutions with their full consequences without necessitating civil marriage registration. Our Muslim Assembly of the Cape, the MAC, also part of this particular matter, asserted that Muslim marriages should be recognized in their own right and analogous to customary marriages, supporting retrospective effect to ensure women's access to patrimonial recourse. They also stressed that contractual regulation under Sharia is inadequate, given women's often limited bargaining power and socioeconomic constraints that exist within the sphere of marriage. In concluding, this is just a brief overview of this particular case and its effects. And its effects are being felt going forward. We have some people in our committee, and I'm sure our speakers will talk about it, dealing with the Divorce Act, Section 7. I think Section 5 has come up with Shaman. We had a discussion about that in terms of a redistribution of assets, forfeiture, I think, am I correct? Forfeiture as well. Also, a Rule 43 application for interim access to recovering or allowing a contribution towards legal costs. That's one of it. The most important one of Rule 43 is that it aligns itself with the Children's Act. And it aligns itself with the Children's Act because, as we know, that in these situations, it's generally speaking, not all the time, the women and the children that bear the brunt of the disagreement. So by the Crown Court speaking to or mentioning the Children's Act, it's analogous to the Children's Act where it says, in terms of Rule 43 application, interim application, what does it mean when you must have communication with the child? And it gives a long list, a very comprehensive list of what is deemed communication or access, as you would put it. So some would argue, so, well, I will visit my child once a week. No, that's not what it means. Oh, I will speak to him via phone. No, that's not what it means. No, I will Skype with him. No, that's not what it means. It means there has to be a consistent interaction between the parents. Consistent, not when the parent feels that I want to have an interaction. And it goes both ways also, that in terms of visitation, it's not just visitation. It's visitation, it's calling, it's WhatsApp, it's Skype, it's Instagram, you name it, whichever social platform exists. You must make the effort to keep the bond alive. And that's the important link I find with this particular judgment, that it aligns itself with the existing legislation that we have, bringing into the picture that at the end of the day, the interest of the child is paramount. And how do we go about doing that? It is comprehensive in how you go about doing it. Once a week visit, no, that's not going to cut it, unfortunately. It is constant. Phone calls once a day, twice a day, every second or third day, a visit in between. You have to keep the bond from a psychological, from an Islamic perspective, whichever perspective you want to put there. That bond must be kept. That bond must not be broken. The child already is broken. So by you being there is to mitigate that. To make sure that, yes, we've had our problems, we've had our differences, we're doing this. However, you are still my child. You are still the most important person in my life. So in closing, from this particular judgment that I briefly just went over, I prepared it last night. Well, not last night, yesterday afternoon already. I mean, I told Sheikh already. Sheikh said, you know, we matured people. We don't say old anymore. It's a derogatory term. We've come to that terms. We say matured people. We still do it the old way. We still do the book and a pen. You know, we're not that tech savvy where we can just like type and there you go. We sit with a book and pen. And I was thinking, how do I convey this particular very sensitive case as well, very complicated also, because, you know, it just covers many aspects. So we try to do our best in getting where we're supposed to be getting. But thank you very much for that. Ladies and gentlemen, I would like to just, I should have done this and I do apologize, that Shaykh Dawood will now give his opening address and he will have a Q&A. My colleagues, am I correct so far? We will have a Q&A for the first session, and Ms Seehaam Samaai then will have the second session in terms of the keynote address as well and the Q&A. So without further ado, Sheikh, I leave it in your capable and spiritual hands to proceed further. Thank you very much.
Thank you and shukran to Dr Ashraf Booley for those kind words. Good morning, everybody, and thank you for inviting me to be part of this very important discussion, a reflection on the Women's Legal Centre Trust versus the President of the Republic of South Africa and others, 2013, way to from here. When we analyze the current state of Muslim personal law in its private capacity, like in Muslim minority countries, the state of Muslim personal law in its current form in Muslim majority countries, and the current state of the methodology in Muslim personal law, it will show the dire need for a new cycle of renewal ijtihad of how Islamic law is understood and practiced at all levels. It is very interesting to note that the legislation of Muslim personal law in Muslim majority countries varies, and there is no one shoe fit all scenario. A debate between the Grand Imam of the Al-Azhar, Sheikh Ahmed Al-Tayyib, and Muhammad Uthman Al-Ghash, the then president of the Cairo University, went viral. Al-Ghash argued that Islam needs renewal by returning to the Quran and the authentic Sunnah. He blamed tradition for preventing advancement in the modern world. He argued that Islamic tradition had become stagnant and that if Muhammad ibn Idris al-Shafi'i was alive today, he would have sought to renew Islamic law. Tayyib responded with a passionate rebuttal and defense of Islamic tradition. He noted that even the idea of religious renewal is from the tradition itself, not from outside. He compared Ghash to someone who seeks to renovate his father's home but opts to buy a new one instead. Ghash is not alone. Many modern Muslims view the Islamic legal tradition as needing a complete overhaul. A consistent theme among several reformers of the 18th to the 21st century has been a call to bypass the madhahibs and approach the Quran and the Sunnah anew. When reflecting on the Women's Legal Center's court case versus the President of the Republic of South Africa, there are two main ideas. If this is an attempt to regulate Muslim personal law in South Africa, how will this be different to the shelved 2010 Muslim Marriage Bill, MMB? Two, is this the spark that is needed to force Muslim organizations to come to the table once again and to revisit orthodox Muslim interpretations on Muslim personal law, be proactive and influence the new act? When framing Muslim personal law, we cannot exclude its overarching hierarchy, which is the Sharia. A clear distinction warrants an understanding between how we view Sharia and fiqh. The latter could be well understood as the mutable laws and the former the immutable laws or the divine laws. Abu Hamid al-Ghazali, who passed on in the year 1111, opines that the purpose of the Sharia is the people's well-being, which lies in the preservation of the faith, the self, the intellect, lineage, and wealth. Whatsoever ensures the safeguarding of these 5 principles is part of the public interest, and whatsoever harms them is against the public interest. Al-Ghazali also made a tripart distinction of maslaha into necessities, known as the dururiyat, the needs, the hajat, and the embellishment, the tahsiniyat. But maslaha-based reasoning was to remain a marginal source for a scholar, given that it was not linked to a specific textual stipulation. The contribution of Abu Ishaq al-Shatibi, the most well-known classical author to write on the subject, was to further promote maslaha-based reasoning as a potentially independent category. This was on the presumption that human beings were able to use their own moral agency to accurately discern the good, the bad, and the maslaha. The words of Ibn Qayyim al-Jawzi is perhaps where we would want to place the judgment of the apex court, the conquered court, and see how we can harmonize it when he says, the Sharia is built and founded upon the good, the masalih of mankind. It is entirely justice, entirely mercy, entirely the good, and entirely wisdom, unquote. The Concord Court attempts to give recognition of Muslim marriages and the consequences that follows from such recognition. Yes, it can be argued that this is a massive win for Muslims in South Africa and much needed legislation to regulate Muslim marriages in an unregulated environment where the court hears cases brought before it, where the strength of legal representation is not only as strong as the legal arguments, but also as strong and weighty as the bank accounts. The tough questions that everyone wants to know in the drafting of the new legislations are: how will a Muslim marriage be defined? Number 2, how will Muslim marriages be regulated in relation to Islamic jurisprudence? Number 3, how will the new act safeguard the welfare of children in the dissolution of Muslim marriages where there are guidelines in Islam? And number 4, how will the new act provide for the redistribution and forfeiture of assets on the dissolution of a Muslim marriage? There may be many more questions still to come and will be coming. However, the main consideration that we need to keep our eye on is consistency with the Constitution of the Republic of South Africa. This is perhaps where we will see a potential clash between the Act and Muslim personal law. The above concerns can be fitted under Yusuf Qaradawi's extension of Ghazali's definition of maslaha, when he says, I would use his original formulation, but say, by maslaha, we mean safeguarding the purposes of the Sharia, and the purposes of the Sharia for the people are to protect their religion, life, rationality, progeny, property, honor, peace, rights, and freedoms, the institution of justice and shared responsibility is what ought to be a moral community, unquote. For Al-Qaradawi's school of the middle way, the centrism or wasatiyah of this school manifests itself by linking a specific text to the higher comprehensive purposes of the Sharia. Like Ash-Shatibi, the proof of this approach is to be found in the way that the Sharia is induced. The reflection upon the text's indications, both comprehensive and specific, as well as the general considerations based on the meaning of those texts. We should keep in mind the holistic well-being in the dissolution of Muslim marriages in early Islam and Muslim countries. The roles that the families played in minimizing the adverse effects of the dissolution of Muslim marriages and the access to state treasury in the form of a Baytul Mal meant that women and children were well protected. How do we enforce such Islamic practices in a secular country like South Africa? Will this be even possible? So, if this cannot be achieved and we are further away from it, is the new envisaged act perhaps the tool of a lesser evil and the low-hanging fruits? Is this perhaps the maslaha to attain some justice? Can the legal maxim perhaps apply? Ma la yutrak kulluhu, la yatruku kulluhu. That which cannot be achieved in totality should not be abandoned in totality. The opposition to the government's new legislation will come from the main actors in the Muslim community. Here, government will have to contend with the orthodoxy, centrism, and liberal views. The obstacle will take the form from Muslim leadership arguing that, number 1, secular law systems are interfering with Muslim personal law. While these laws are to build upon the Islamic fundamentals of family, they are protected by the authority of the state. And even though these laws are established theoretically in order to bring about balance in the society and to protect the weaker parties, their rulings may violate Islamic law and may permit that which is prohibited in Islam and prohibits the permissible. Number 2, Muslims are caught between two contradictions when it comes to dealing with the family law in Western societies. On one hand, some Muslims resort to Western laws exclusively without considering whether these laws conform with or violate Islamic law. On the other hand, there are those who hold the belief that these laws are invalid according to the Islamic law because they represent an authority of a non-Muslim over a Muslim. If truth be told, we are where we are because of our own failures as a Muslim community. Why is it that the Women Legal Center had to take government to court? Many Muslims, many women are adversely affected in the dissolution of their marriages. And why is it not addressed by the powers that be in the Muslim community? Why aren't the contributions of women quantified in the subsistence of the marriage? We find that Muslim women approach Muslim institutions for judgment on issues pertaining to marriage and divorce. However, because Islamic institutions neither hold official authority nor do they claim any executive powers by Islamic Sharia, seeking their judgment has unfortunately caused many issues and a failure in handling many actual violations of Islamic law, as these violations require authority and power for the execution and the enforcement of verdicts. So, should Muslim women continue to suffer in silence, or can they approach the court for relief and help? In addition, judgment may be given on one Islamic school of thought or another, but may also lack the ability or the courage to offer a contemporary deduction suited to the realities of Muslims living in Muslim minority countries, like post-maintenance divorce. Most importantly, those decrees lack the executive state authority to guarantee the fulfillment of the rights to whom they are due, especially women and children, and to help avoid oppression and harm many men cause their wives or ex-wives. This lack of morally conscious individuals and state authority causes the transgression of fundamental limits set by the Sharia in domestic laws. The closest concept to find some recognition to the new legislation is the theory of fiqhul muwatana, the fiqh of citizenship. This theory is supported by Tariq Ramadan when he addresses Muslims in Europe. Tariq Ramadan's thoughts have been widely discussed and are considered as a way out for the contemporary problems. He represents the meeting of traditional Islam with Western modernity. His ideas revolve mainly around two major themes, namely renewing and reforming Islam and the place of Islam and Muslims in Western societies. Ramadan suggests a reform that involves a holistic redesigning of the methodological approaches to the interpretation of Islamic jurisdictions and ethics in all aspects of life. Therefore, according to Ramadan, using the reasoning tools to interpret the sacred texts might free Muslims both from the interpretations of established edicts and from cultural norms. In addition, these tools enable the believer to practice her or his own faith through her or his own interpretations and introspection. However, this does not mean the worshipper should create his own version of Islamic principles and teachings, but rather he or she is free to read and interpret the sacred text in the light of the context they live in. He claims that he aims to remain faithful to the principles of Islam and Islamic teachings on the basis of scriptural sources, while taking into consideration the evolution of historical and geographical context. He tends to be against the literalists who only rely on quoting verses from the Quran or quoting Prophet's statement without taking into account the context. He tries to interpret the Islamic teachings in the light of a modern time to fit the context of the West. On the other hand, the scholar believes that to avoid a clash of cultures and civilizations, Muslims should not focus on the tradition they had brought with them from their own country. They have to adapt to the social environment they live in, taking into account the cultural reality of the West. So, according to Ramadan, Muslims have no choice but position themselves in the middle of a very different society and get along with the principles of that society. Tariq Ramadan tried to emphasize the fact that if Muslims do not adapt to the new social Western environment, they will face difficulties and challenges, especially in terms of integration. In other words, if Muslims want the Islamic identity to be preserved in a Western social environment, they need to make changes and adjustments. In trying to understand the theories of Tariq Ramadan, we can arguably state that it is aligned to the theory of Islamic jurisprudence, or the frame of istihsan, where it is a method of exercising personal opinion in order to avoid any rigidity and unfairness that might result from the literal enforcement of the existing law. As Sharakshi considers istihsan to be a method of seeking facility, ease in legal injunctions. In conclusion, we don't have to search that far for answers to Muslim personal law. We sometimes debate the discretionary issuing or abuse of talaqs by the husband, whether it is 1, 2, or 3. However, the Islamic legal frames for women to dissolve their marriage equally takes 3 distinct formats. A fasakh, which is a judicial divorce, a decree; khul, where she returns her dowry given to her; and tafweed, the ceding of divorce to the wife. It is here that Muslim organizations must be more flexible and facilitate ease to the wife and empower Muslim women. Finally, it is the wife that should dictate the marriage and not the husband. The concepts of kafa'a, equality, and dictating the terms of the marriage contract, dowry, and maintenance are all the rights of a wife. If the marriage contracts are drafted properly, it should have legal standing in the court of law. Thank you.
Thank you, Shaykh Dawood. Inspiring words, most definitely, and I think definitely to consider going forward. So we have a Q&A. So I'll open the floor. Anybody's got a question or comment that they would like to raise. Perhaps I will start, if I may. Just comment here. If we look at the North African countries, Egypt, Tunisia, Morocco, we find that to a certain degree they have codified their Muslim personal laws, albeit with a particular agenda in mind. And I say that because being colonized by the French, so for a long time the French left the Muslims totally on their own, not interfering in any religious doctrine, fearing that there would be a revolt. Having said that, when they finally came to the point where they were, or gained independence, they had this unique lacuna or opportunity to actually codify the Muslim personal law, because at that particular time, there was dissension in the ranks, the various clans, if you want to call them that, lots of infighting. And Habib Bougheré, who was then the president, the first president of independent, I think, Tunisia, came up with the idea that in order to fill this and to bring the ulama back, was that he was going to codify the law. And many people have asked me, so what seems to be the problem then? That if we have countries like Tunisia, which is the majority, and Morocco and Egypt, majority Muslim, Sunni or Shia, irrespective, but a majority onto 99%, what seems then to be the problem in South Africa? And I sometimes grapple with that in how to answer them in a way that reflects the ongoing debate that we have. So just perhaps a comment on that, because you mentioned the issue of the Muslim minority countries and the Muslim majority countries. So if you could just perhaps expand on that for me, please.
Yes, yeah, I think the challenge, because we in the heart of the Muslim community, and we operate there, we see sometimes the challenge between the North and the South. And that becomes a reality. If we take the case study of the 2010 MMP, a lot of discussions around that, and the opposition that came with that, is how to really locate that particular conversation of the then drafted MMP that shelved, and make sense of it and land it in a place that we can codify the law. So there has been that sincere attempt. However, sometimes the gatekeepers of the Muslim community, in finding themselves in realizing that they are in a Muslim minority country, becomes sometimes the obstacle. For example, we find that people from the north, so we're talking about here maybe Gauteng, Pretoria, they sit with when the husband issues their wife with 3 talaqs in one sitting, the solution of marriage in one sitting. So the law up north, and which is really complies to Muslim person law in itself, is that that particular the solution stands and it's valid according to all religious schools of thought, right? And so now it creates a challenge. So what happens is that those particular people come down perhaps to Cape Town, not to say that they are perhaps less strict in the interpretation or the application of the law, but they understand what goes with that. For example, there needs to be an interview. How did you understand actually what happened when you said divorce, the triple divorce? What was the scenario like? What was the situation like? And so in certain cases, that triple divorce is overturned to one, right? If there are clear answers and justifications to be given. So when we're looking at the codification, because if we're looking at, we are 3% of a Muslim population, in South Africa, majority, in the Western Cape population. The MGC itself, has a Sharia court, Just yesterday I asked the administrator, just give me a bit of an idea, although we belong to the organization, what are you doing really in that particular court, a Sharia court? And so he says, yes, so the issues with fasakh is predominantly touched because it is to do with a judicial, issue of a divorce, taking away the rights of the husband. But when it comes to even having administrative justice, whereby they are also facilitating a talaq, which is the prerogative and the right of the husband. So if he gives it in the privacy of his bedroom, house, car, whatever it is, it stands. But just to facilitate it, so there can be no comebacks or questions about it, it is a movement in that particular direction. So I think in response to the question is that when we are perhaps too settled in the interpretation of the text, it becomes very difficult to move to a codification, of Muslim personal law, which I mean we're supposed to be having. It's supposed to be relatively easy, but by way of a case study, it's very interesting. Is that why is it that Islamic finance is kicking off?
Sure.
Why is that becoming so successful? So even if you look at the actors in that particular space, they realize that they cannot be reliant on one particular. Otherwise, Islamic banking system will fall flat. Why aren't we giving that recognition, to Muslim personal law and come up with a codification that we can all accept? So sometimes we are enemies in a Muslim personal law, the MMB. The obstacle came from certain quarters in how it was drafted. So we sometimes, our own enemies. I hope that answers a bit.
I sometimes struggle with that, thinking that those in the power versus those in the masses. Why is it that the masses cannot topple, those that are the minimum that's there? It goes for any government for that matter. That, why is that such an obstacle? Like,
the largely was probably respect. I mean, we have our students sitting here. We brought some of the students. In fact, the entire class of 30 wanted to come. So they are our law students, Islamic law. And the BA3s also wanted to come. So these are discussions that we're having in our community. And until such time, we create that space and have the discussion to influence society and community. So if these are the next generations of leaders, right, understanding that they cannot just import an understanding of a place where they've studied, for example, and that it's nothing wrong with that Islam, it's perfect, it operates there. I lived abroad, but to import it in a country like South Africa will be challenging. So the conversation needs to start, and I really love the idea of where UWC is moving into that particular direction. And so that collaboration between, UWC and IPSA, should really be taking shape and form. Because, I mean, if these are students that we have 30 in the class, next generation, and we are producing more than, we existed for the past 20 years, and we have produced 1,000, graduates coming to the system, one can then influence the public.
The thought process going forward.
That's right.
In the newer generation. No, thank you, thank you. Yes, you might, please. Mr. Wilson.
I think to answer Ashraf's question, it's the masses that also part of the job. It's not just the state and leadership. It's the masses as well, because that is where we have challenge with it. Because certain quarters, even women who oppose it's not just that is part of it.
Any questions or comments, perhaps? Feel free. Okay. Go ahead, please.
So just three things to touch on. I was curious to know what measures will be put in place to ensure that women who have been indoctrinated by Western models and values do not abuse this more inclusive system for personal gain. And how do we draw the line between istihsan and hedonism, and who gets to, or what qualifies the person to decide where this line is drawn? And yeah, these are just 3 points I'm curious of in terms of preservation of tradition.
No, absolutely, I agree with you, if I may.
Yeah, please.
I do agree with you, and this is where the actors in society, the leadership needs to step up. This is where we expect leadership to come, the community. So why is it now we are 1 year away from impending legislation? Are they proactive in speaking to government, those in authority? How can we find harmony? We have a constitution that is there, right? And all of us are bound to follow the constitution. So if we are not saying that we are watering down the Sharia in any way. The Sharia will remain. It is the divine law of the Almighty. but there are those that does fall within the realm of fiqh, where it has adaptation of time and space. And therefore, Imam Shafi, for example, in the latter 4 years of his life, when he went to modern Egypt, he changed his view. And this is where we need to begin to understand that the codification that we spoke about then, is it applicable to where we are sitting right now in this time and space, without compromising our religion and identity, you know, as Muslims. So when we are talking about why has it been successful, you know, at the beginning of time and Muslim countries, is that the system allows for that. So in other words, if a wife had to be divorced, she then a family takes that particular responsibility. If the husband has passed on, his family is supposed to take that responsibility for her. And so why isn't that happening in our communities today? So they are left alone. They have sacrificed so many years of their life to build, you know, the household, even the wealth of the family. But that is not quantified in itself. So you are sitting with the problem. It is a catch-22 situation, undoubtedly. And yes, so it can be abused. But I think in this new legislation, the ultimate frame that we will have to work in is going to be the Constitution. That is, you know, where it's going to be. And so I don't know whether marriages moving forward is going to be by default under that, or whether they should now apply to fall under that particular system. That is where most probably a conversation needs to take place, because if it is that they're not necessarily that will fall under automatically that particular system after 2026, or there's some sort of interim relief, it then means that the status quo will remain. Which then means that women will either have a right to approach the agency or other organizations for relief, whether that is enforceable or not, or decide as to know whether they want to approach, you know, the court system for that. So it is a very challenging mark, I must say. It is a conversation that will definitely take shape and form, and that is where the obstacle is going to be also.
Well, do we have an idea of the end still being perhaps those in charge of, for example, organizations like the MJC or other people when they go in, or any ideas of that?
I think there's been a lot of maturity within the MJC, ranks of the MJC. They have consulted broadly.
If I could also make a comment on that, I think also with the Sheikh,
Yes, you follow.
it's taken on a board. It's very much younger board, executive board, and I would like to say probably more in touch in terms of social media and activism. So I think starting at that particular point, in terms of the Muslim Judicial Council, that the board that has been elected, which much younger board, a board that's more related to grassroots level, knowing what is happening and being in touch with the community, whereby we could possibly put an argument forward that say that the previous boards dating back maybe to the 80s was stoic in the stance and belief system, but the current board, it's a very energetic and youngish, mature board compared to its previous board members. So I do see that they are opening, and Sheikh rightly said there's also a court system that's in place there, or a tribunal system where FASA can be heard. But there are still obstacles nonetheless. And even if we eliminate those obstacles, new obstacles will continuously arise with society. And that's just a given. But in terms of the board, I think having a younger board there will also facilitate the change, will facilitate the talk of where it should be going in the process that we are now. And I see the board as not as hindering, where I would actually have made that comment a couple of years ago, probably in the 80s. I see it now actually being more forthcoming, more deliberate in its arguments, and saying, this is the route that we should be going now. We should be leaving behind, not changing anything, but realize that this is not happening. Like Sheikh points out rightfully there, when they get divorced, the wife contributes to the household, but is left with nothing. That should not be the case anymore. So these members, the new board members have realized this, have gone through that, have seen it. It's become a reality in today's society. So I hope that they will take cognizance of those particular issues there and then carry the conversation forward. I think we got a question at the back.
Dr. Shukran, so much for your enlightening speech as well. I agree with a lot of things and your sentiments made. I just want to mention one comment and perhaps a question as well stemming from that. You mentioned earlier that the regulation needs to find spaces within the Constitution. Now, according to my research and according to my experience, I'm of the opinion, although I do agree with that, I'm also of the opinion that the problem doesn't lie in the system itself, referring to the Sharia law system. In our South African context, my finding is the problem lies in the enforcement of those rules. So that's my first question or comment rather. And the second thing that I wanted to mention with regards to this was also, just about mine now as well. Yes, the reconciliation between the two. Is it possible, following on from that question, is it possible to fully reconcile and combine Sharia law system with the Constitution? Because according to my knowledge, I don't think that is fully possible. It may be partially realized, but fully I don't think so.
So shukran for those two questions. So enforcement is where the problem really is. That is where it is. That's why we are where we are today. Is that the husband will, just abscond and feel that why should I come to a hearing just to facilitate a discussion to hear his side or even her side, right? It goes both ways. So what do? Where is it that you as an imam that deals with it in your private capacity at your home, where they are coming and you want to facilitate a discussion, when you want to give that guidance? Are they even open to those Islamic guidance that you're given? Because that is what you are giving them. So they're opposing that Islamic guidance, that prophetic wisdom that is given there. So they're opposing that. So you are sitting with the situation, with what is happening in their mind, feeling that they are now being oppressed or they're being wrong, and accepting what the Sharia is saying. So you want to guide them along, but enforcing that is where the problem is. So women will say, well, I don't have to appear. Who is the MJC? Or who is this particular organization? What is that particular organization? That is where your problem is. So you're finding this, to the second question, you are not going to be able to harmonize in totality, between your Sharia and your constitution. So do we throw the baby out with the water? That is where the question is going to be. So, like we've cited the legal maxim, that which cannot be attained in totality shouldn't be abandoned in totality. And so how do we now activate a conversation between the powers that be? Where can we meet each other on this conversation? So maslaka that doesn't have textual evidence, or istihsan that has textual evidence, but causes a bit of a challenge for the wife because the system doesn't allow, because they're abandoned by their own family, there's no financial support. What happens then? So we're sitting with a frame that we can work in. Are we going to be bold enough to take a frame of usul fiqh, Islamic jurisprudence carved out over centuries, and say, listen here, let's adapt it perhaps to this? Because of our condition. Because even in edicts and fatwa, it is based upon the social conditions of time and space. And therefore it may adapt, it may change with time and space. So,
just have a question. Based on all the seminars and so forth, and I felt that the question wasn't answered, at least not to my satisfaction. Maybe I misunderstood. But one of the previous presenters says that Islam protects women. And the difficulty I had with that, well, if that's the case, why are women going to court? And one of the concerns with the Women's Legal Center is obviously the application of the Divorce Act now, and particularly the distribution of assets order. And so I said, well, I asked, well, then what remedy is there? So when we speak about going to the MJC, the lack of enforcement, what enforcement is it? Do we actually start at divorce, or should we start at contract stage, securing? And why is there maybe not, we should know this, I suppose, but if you don't go for marriage classes, are you really going to know your effective protection? And so then obviously it ties up to the reality, well, the men must protect my father, what if my father has passed on, what if I have no uncles, what if my brother. So when we speak about enforcement, then are we talking about that order being enforced against my brother, who will then have to, I just want to know where do we go, and with this redistribution of assets order, which obviously would then apply because it's not an out of community or property marriage, but I think it's more sacred with the Muslim marriage, and that's the point of redistribution. I make an indirect contribution because I stay at home and I look after the kids. So it would seem that that could be a great remedy, but from my understanding of what was said, it's not necessarily compliant. So what then, when we speak about Islam protects, because the reality is that the relatives are not doing so, how do we enforce that against, but you must maintain me now. Is he going to still want me under his roof? What is that protection there? Because I think that's maybe where we are struggling.
Yeah, yeah. Okay.
No, this is your your section. It's a lot for me to come out.
Yeah, so you have to turn your yeah. So I mean, even if you look at this very term marriage, you call it up to nikah, right? And I think this is where we miss the boat. If you open any classical text, you look at up to nikah, it's a marriage contract. I've entered in the conclusion. I said it's predominantly dictated by the wife and not the husband, because she sets the foundation for this particular contract. And so often when we speak to our students, you know, at IPSA, we says that largely they must also take responsibility because they're so madly in love and they don't mind sleeping on the floor and eating, you know.
Big wedding.
Yeah. But they don't come to the realization. And therefore, what we sometimes do is that we bring the reality into that space. You understand? So if you are not, so it's, when we're talking about Islam protecting, it's sometimes we are failing to understand what Islam gives us. So we're actually failing Islam. Is Islam failing us? Or are we failing Islam? So when that protection happens at the very beginning of that marriage contract, that is where you specify. For example, you know, when it comes to dowry, I spoke about dowry, right? So do women devalue themselves or not? So every woman will say, well, I'm worth X, Y, and Z. But when it comes to the dowry being stipulated, she would now compromise on the dowry based upon what the husband can do, right? And what is within his means, which is a negotiation that takes place. But does that really need to happen? Can it be inserted in the marriage that we will grow this marriage together? You don't have R1 million for me today, but maybe in 20 years' time you will have R1 million. I will help you grow that. So that is my dowry.
She's also like an accrual.
Absolutely. So you have the 3 types of dowry: immediate dowry, the deferred dowry, and it can be staggered. Why isn't that a discussion that we have? We take that to our students always. But why is it that you have to settle on X, Y, and Z? Because you are contributing. Sometimes you're saying indirectly, but it's actually direct contribution that is happening. Maulana Yusuf Al-Karam, when I came back in 2002, I served with him in the Fatwa department for 2 years. And we're doing a Lost World and Testaments, we're drafting it. And, you know, the lady came to us, the husband and the wife were sitting and drafting the Lost Will, and Maulana Yusuf asked the wife, have you contributed to this marriage? And the husband was like, yes, my wife has always been there for me. She helped me and everything. I am where I am today because of my wife, the role that she played. And then Maulana Yusuf Quran said to her, only married by Islamic rights, nothing else. So Maulana Yusuf Quran then said to her, but then you are deserving of his assets. And in that wills that we drafted just on Islamic wills, he then said, you quantify for us. And most of the time, you would quantify it as 50-50. So I know that I've been in that space. We've drafted in that particular way. So why isn't that conversation being held when people are drafting their wills?
a very valid point you make about the words, for example, if I may interject. Because if you look at the Quranic verses, it says clearly, after request, after request. So the request is first, and it doesn't limit request to one to absolutely, so, but we don't look at that.
So there are answers, for us. It's our just limited knowledge in the space. Because we come from an Islamic law background, so we've studied this, so we know. And so if we are not going to be speaking about it, if we're not going to have students like this, we'll actually ask these hard questions and also empower themselves. Will not be able to change society. Will not be able to change society.
And so in those instances, if you're gonna go to the MJC, you can go there, but then if he doesn't comply, there's nothing that can happen because they don't have. Okay.
So it's a moral conscious decision that you make.
Yes.
It's a moral conscious decision. Because you're appealing to that, the language that you are speaking is about them. Please conform, but you can't enforce it. How do you, because you must remember it's also a private space. You can't go beyond that private space.
Okay, you should come for that, Sheikh. I think we're running out of
Yeah.
time or something. Just a quick comment, if I could. I think when it comes to marriage and marital contract, and I speak under Quran, please correct me if I'm wrong. I don't think in the Quran, when it speaks about marriage, it speaks about the actual marital contract. However, I see where it deals with orphans, in particular, it refers to a contract, and therefore influences can be drawn.
Justice, the actual justice.
It's excellent. So just for that. Yeah. So we're going to move on to our next speaker.
Yes, I think we have two questions on our online.
Oh, sorry, my apologies.
I'm gonna just hand over with your permission to Ms Safari. You just unmute it and you can ask your question, inshallah.
Salam, am I audible?
Yeah.
Okay. So I just wanted to ask, it's a question and I think also kind of in a comment. I think Dr. Booley spoke about the board, of the MJC and stuff, and that it's like a new one that's more knowledgeable about these issues. So I was just wanted to know if there is any movement with regards to having more women, women on the board to be part of that decision making process. Because I think there is a gap in that when it comes to stuff like that. And then also with regard to I don't know any of the speaker can comment on this with regards to the marriage contract. I know the previous speaker was speaking about the negotiation and all the stuff, but I think it comes down to whether there's an appetite for that in our community. Because I was writing my research paper on this, and I wasn't able to do proper field work research, but just from my conversations with women I've had who are getting married, it just doesn't seem like there's the knowledge about it, the promotion of a marriage contract and that negotiation, also an appetite for it, to be able to enforce that in a South African court of law. So yeah.
If I can, that's a very important point that's mentioned by our online attendee. She did a research paper with me, so I know them, but she's talking about the marital contract. So what I find is that a marital contract to me is a legal contract for all intents and purposes, and I think it can stand up in court. It's as simple as that, where two parties come together and they agree on something. And if you want to look from an African perspective and say whether it's lawful, okay, it's lawful, fine. If you want to look from an Islamic perspective, it is lawful then there is no reason why the court will not adjudicate upon such a matter and not give a ruling on such a matter. So I think it's vital that these marital contracts, not just going by its name being a marital contract, it is a contract nonetheless, period. That's it. So I think the courts can. Yeah.
Contract, so maybe it's pre-contract phase, I think, where the problem lies, and maybe whoever the couple goes through is not emphasizing protect yourself. I don't know if that could be the case. Well, these are all the possibilities for you.
Yeah.
Well, one more question, Mama.
Yeah, but we can just add quickly just to this, and I think maybe it will be, very good, Prof. Booley, 2 years ago, contemporary Islamic law in our honors class, we had our students, do a marriage contract, Muslim marriage contract. And this is perhaps where we could give that particular data, to UWC and, align it, to the law itself. So I think if we can really promote that in the absence of something that is substantial, then, we could be helping our societies and our communities, itself. And secondly, just to the sister, on the, so I'm a member also of the MJC, and I can say they've been very progressive in accepting women to be part of the MJC.
Okay.
And so the constitution of the MJC allows women to join, the MJC. And I think that was in 2015 roundabout day. So the wife of Mawlana Eke Ali Khadija Patel, she served as an executive member on the board of the MJC. So there is space, there is room. It's just whether you have the appetite, for that, conversation, to happen, and to make the application, to the MJC.
One more question,
I
Mama.
guess we have another question from Ms Shireen Ibrahim. I'm going to unmute you now. You can just introduce yourself and then ask the question.
Thank you. Can you hear me?
Yes, we can.
Okay. Assalamu alaikum. And it's quite a good session that we're having here today. Mine perhaps is more of a comment. I'm wondering, why are we as a community stuck on whether there is compliance with Sharia or the Constitution? And I think that if we look at the Islamic value system broadly, we'd see that it speaks to fairness and justice. And isn't that a better fit in terms of moving towards codification rather than ensuring that every dot and comma is dealt with? So that's one point. And we need to recognize that the Constitution looks at removal of prejudice to Muslim women. Doesn't Islam do the same? Perhaps differently. So there are lots of common areas that we could work with to ensure that Muslim women, children, and men are not prejudiced in terms of a move towards codification. And then I also wanted to say, even though we may see women being allowed onto bodies like MJC, etc., is there an enabling environment for them to be heard? So for me, if we need to look at taking this process further, we need to ensure that the environment and the context is an enabling one that allows all voices to be heard and certain principles to be adhered to. So that's one. And secondly, we need to start at grassroots. At all the imams that are contracting these marriages, they need to be trained both on fairness and in terms of constitutional principles in order to ensure that no prejudice is experienced by the couple whose marriage they're officiating over. The South African Law Research Commission had come out with a paper which spoke about many of these things, and we had made contributions to that. And I think instead of just, whilst it's good to have discussions, is there a group who could perhaps raise with the South African Law Research Commission, Department of Justice, Department of Home Affairs? There was a move towards ensuring that, I think by many of the organizations, that we move towards an omnibus approach for Muslim marriages. And why is that not being taken up by the community itself? Now, I know from the perspective of government, perhaps it is too expensive, etc. But you need to get, and I'm going to perhaps move away from calling them actors because I'd like them to be genuine. We need to move towards getting role players who are going to be making a difference in our talks and discussions. One, the Minister of Justice. They're moving towards, the Department of Justice is moving towards a general marriage bill, which accommodates all marriages, not just Muslim marriages specifically. And I think those are the discussions that we need to start having as a community in order to ensure that at least Muslim women and children, their interests and the community's interests are safeguarded. To still argue about whether we are fully Sharia compliant or not is not going to take us any further in this discussion. Shukran.
Thank you very much. Perhaps comment.
Yeah, just on the MGC, and I think is that as I've indicated, the voices of females are being heard, and so they do participate in the monthly meetings, which is general majlis meetings, and if they are elected, through a vote, they will serve on the executive, the highest decision making body within the MGC. So we had Sister Khadija Patel, who served on that particular platform. So yes, we have quite a few women who have already joined, but I do think we need to have more women join, and if you can create that safe space, and that's all that is required. It's actually create that safe space to be heard, then I think we will be able to achieve a lot. So yes, it is open not just to the people from the ulama fraternity, but anybody who can actively contribute to build the MJC. So yes, definitely there is room for those particular voices to be heard. I don't know, Prof, you want to know?
If I check, last question, and we have to move on, unfortunately.
I just have two questions.
She's one of the last who joined the MGCA, just by the way. She's one of the last members to join of the females.
Dr. Dawood, what role do local and religious leaders and scholars play in shaping community attitudes towards reform? And in the intersection of Islamic jurisprudence and the constitutional law in South Africa, in the South African landscape, what role can ijtihad be able to bridge that gap between Muslim law and the constitutional rights?
Yeah, just briefly then on that is that with regards to the role, I think they have a very important role to play. I mean, if we are producing the next generation of scholars, they need to be able to bring awareness, and they need to create forums like this within the community. So they have a very important role to play. We cannot underestimate, because largely our communities still respect the leadership. And so if they are still respecting the leadership and they're still listening to them, then they have to use that which they have in forwarding and promoting these particular discussions. So ijtihad plays a very, very important role. So yes, you may have clear-cut laws that are there, but when it comes to the matters that are not of fiqh, there will be room for ijtihad. Otherwise, why are these particular terms still alive? Why do we still use the term fatwa, for example, legal ethics? So there's a framework to work in. So if we are saying that it's 1,400 years ago and that is we are parking it, then it means that ijtihad, the formation and development of ethics, it's non-existent. So it does have, it's just finding that space, how we're going to maneuver that in the space of Muslim personal law, where there is some sort of codification, and can we then use other disciplines and frames, in that.
Thank you very much for the questions. Thank you to Sheikh Dawood there for his session. I think we have our next presenter. Our next presenters. Mr. Silo, you can have a seat for us. Let's have a seat for you. So Mr. Silo's topic for discussion is Muslim personal law, secular promises, the future of legal pluralism in post-apartheid South Africa. You may proceed.
Well, thank you so much.
Pleasure.
Okay, thank you. Good morning, everyone. Thank you for having me here, and I'm also grateful for the opportunity to be presenting today my my paper. So my name is Andaselo. I'll be graduating for my master's in law on Friday in legal pluralism and family law. So thank you so much, and my apologies for I didn't know which picture to hold, so I was like, let's just embrace the diversity of South Africa because it is beautiful. So my paper focuses mainly on the interpretation of the judiciary in terms regarding cultural rights and religious rights. So I first start as to explain the background of the of South Africa before 1994, where we experienced a hierarchy of legal systems where we had, for example, the common law and the Roman Dutch law as the dominant legal system. And then it was African customary law, which was recognized only to a limited extent, provided that it was compatible with the rules of repugnancy, which is Western civilization. So after customary law, we had also a religious legal system that were somehow largely excluded and only exercised in the private spheres. So my that is the real brief background of my paper, and also which speaks which takes you back to the introduction of the Constitution of 1996, which is a transformative constitutionalism. Somehow, somewhere in this paper, I use this vehicle of transformative constitutionalism as a way of a tool that will help, that will assist the judiciary in terms of interpreting religious rights and cultural rights without actually eroding them. So, first of all, to give a big background about transformative constitutionalism. Transformative constitutionalism is a theory that basically is a theory of interpretation that basically aims to redress the injustices of the past, guiding us to a better future. So it says during interpretation, we must use the values, the founding values of the Constitution, which is human dignity, equality, and freedoms, to guide us in adjudicating whether it's religious, it's religious practices or cultural practices, which means it might be customary law or African customary law. So through this interpretation, I'm sorry, I wanted to, can you just,
Thanks.
Are you controlling? Okay, thank you. Then just put the next slide. So you will find my problem statement for the paper, which is South Africa still grapples with the challenges of integrating constitutional values within its plural legal system, meaning that somehow during interpretation or when these religious practices or cultural rights in front of are disputed. So what the judges in many times they often do is to rather invalidating those religious practices or and cultural rights rather than developing them. So my paper actually focuses, as I said, on judicial interpretation, which means hard cases in relation to this paper is are the cases which relate to religious practices and as well as cultural practices. Just not to confuse you. So, and sorry, take me through my argument. Yes, my argument. So the paper argues that the court's interpretation of religious and customary law should be guided by transformative constitutionalism, which can be understood through the hermeneutics of Hans Gardner, which is a theory that used to interpret religious texts. What does this theory of hermeneutics mean? It emphasizes a dialogue, a contact, and mutual understanding. For example, if ever we had to have a religious practice or a religious law that violates against rights of the people, the first thing that we have to do, the judges should do, is to go and look at the meaning of at the values of that particular practice. What is its historical significance? What is the importance of that religious practice? Rather than looking it through the lens of the foundational values of the Constitution. So this theory of interpretation can provide an interpretive tool that meaningfully engages with plural legal systems. And I also argue in this paper that in order for us to achieve a deep plural legal system, judicial interpretation must be complemented by community-based legal education, because it is so important. The community-based legal education is so important. I will tell you, I will make an example to you. I will make an example. So, I grew up in the rural areas, Eastern Cape. A lot of people there, those that are, for example, many of the people in rural areas are not really that well educationally informed. So they enter, for example, in these marriages, and when, for example, they divorce, they don't have access, for example, to legal proceedings, and however, they are not aware of actually the law, the Constitution, which is your equality, protects them. So in this, I argue that community-based legal education, teaching our religious communities and our, like for example, our also traditional communities about these foundational values of the Constitution is important, because through that, our communities will be able to integrate their religious practice with the constitutional values. So that's my argument. Can we just put me on the next slide? So the methodology, of course, I will be doing a qualitative study which will be guided by Gadamer's theory of hermeneutics, which is the theory that I've just explained, a theory of interpretation, and which is also complementary to transformative constitutionalism. So, yeah, and so after that, can you please take me to the following slides? That is the process. That is my method. That was my methodology. For in this paper, I will also give a bit view for those that might not know what actually is a deep plural legal system and a weak plural legal system. So a deep plural legal system denotes a coexistence and interaction of two or more legal system within a social field. So, for example, we have your customary law, we have your religious law, we have statutory laws, we have which are also part of state laws, as well as common law. So a deep plural legal system would, in this instance, mean that all these legal systems contribute equally, which means that in the Constitution should be reflective of all these legal systems. How? Maybe integrating the foundational values of these legal systems. For example, if it's customary law values, you integrate foundational values of customary law to the Constitution, as well as Muslim personal laws, you integrate the foundational values of Muslim personal laws to the Constitution. So that's how a deep pluralist legal system could be. For example, an example of a deep plural legal system, take an example of Bolivia. Bolivia has a plurinational constitution which seeks to redress the injustices of the past of colonialism. So what they have integrated in their constitution, they have put all the values of their indigenous people and also the Western law that they have incurred through the period of colonialism. So that's what a deep legal pluralism, a deep plural legal system should look like. So we also have a weak legal pluralism, which would denote a situation where two or more legal systems operate within a society, but which are subject to state recognition. So I put there a question mark. Where does South Africa stand between a deep plural legal system and a weak plural legal system? To answer that question, I honestly of the view that South Africa still has a weak plural legal system, because all our laws are dependent on the state for their recognition. So here on the next slide, oh, thank you so much. On the next slide, I explain this theory of hermeneutics in terms of adjudicating hard cases. As I've said, this theory is a theory that was used to interpret religious texts. However, it is important in our everyday society. This theory teaches us to practice, to interpret practices within their own context, rather than imposing external assumption, which means that if you were to interpret, for example, a religious, a Muslim personal law practice, the first thing that you go through the foundational values of that religious text. You don't look to it via whether it violates equality, whether it violates, you first start looking at its own values, at its own purpose. What is its initial purpose? So this theory is also important. Applied in legal pluralism, of course, it would mean that courts should interpret religious and cultural practices by first understanding their foundational values, dignity, justice, fairness, and community harmony, rather than judging them by the constitutional values. So it says during the interpretive approach, during the interpretation processes, the court will not abandon the constitutional commitment, which is the commitment to the values of human dignity, equality, and freedoms. This theory rather means that courts would have to ask whether the cultural or that particular religious practice or principle is complementing human dignity. Does it complement equality and freedoms? If the answer is yes, the practice should be respected. However, if the answer is no, only then that the court can intervene. Intervention should not erode that particular cultural practice or that religious practice. It should rather develop it. How does it develop it? Develop it would be just based on the community, on what the community has developed. Whether the community has it developed it before. How would the community develop it, the practice, rather than the court saying that we are going to develop this practice in this particular way. So, yeah, so I also make an example that I reflect on the Women's Legal Center Trust, which is the president. Can you take me? That's the next slide. That was the okay, yeah. This is the next one. The next. Yes. So I highlight the court case, the Women's Legal. I highlight the Women's Legal Trust case, and the important question that I can highlight there is, from that case, from that judgment, where do we go from now on? This is where community-based legal education remains so important. Teaching our communities to play a role in upholding the values of our Constitution, the equality, human dignity, and your freedoms. We, in doing that way, rather than seeing them as intervention in our religious practice, we should also see them as complementary to our cultural and religious practices. By doing so, because one of the problems that might arise, yes, the judgment was made, but now think about the ones that do not have the understanding about the values of the Constitution, which is your equality, human dignity, how they will be prejudiced, how they will be ignored in ensuring that, like in terms of ensuring that they have they are protected in terms of human dignity, equality, and freedom. So after community-based legal education, we can truly achieve, I believe, a deep plural legal system. And I will conclude by saying this: a deep legal pluralism should not be seen as an obstacle for the protection of human rights, particularly the gender equality. And thank you.
Thank you, Andrew. And now I would like to open the floor for any questions. Yeah. We have a question then. Please proceed.
In your view, what are the main obstacles to achieving a deep plural legal system in South Africa?
The problem that we have, the Constitution, that is one of the biggest problems. If you look at the Constitution, as much as it is an important document which protects everyone, but if you look at it, you see that from these religious, for example, Muslim personal laws, customary law, you will not even see their foundational values in the Constitution. I'm not sure if I'm making sense. So we have a situation where it's more like the continuation of what we had in the past, in the colonial period, in the apartheid period, where these legal system, your customary law, your personal, your Muslim personal laws are still subject to the repugnancy clause, which is now camouflaged by the concept of the bills of rights. That is the problem. So it's very difficult to achieve a deep plural legal system because of that.
How can demographic factors such as the minority status of Muslims in South Africa impact the implementation and future development of legal pluralism?
Legal pluralism.
Yeah.
The first, as I said, community-based legal education is very important. The leaders of Muslim, for example, Muslim practices, as well as, for example, traditional leaders of which under the umbrella of customary law, they should be the ones being equipped to educate their communities about the values of our constitution, about making sure that they uphold your equality, your human dignity, and your freedoms. Every practice, every religious practice, every custom should embrace those values of the constitution, which is your equality, human dignity, and freedoms.
You got a question at the back?
Yeah. Thank you, sir, for the presentation, and congratulations on your graduation this Friday. We often say that, and we're very proud to say that the Constitution of South Africa is the most progressive and advanced constitution, right? I think it is. I mean, I would assume, based on your presentation, there are some question marks. And then, in your assessment, is there any constitution in the world that is inclusive, that can be used as a case study?
I mentioned, I'm not sure if you did, but thank you so much for that question, sir. I mentioned the constitution of the plurinational state of Bolivia, which is so, I was looking at it, but in terms of practically accessing it, how has it been enforceable? I'm not quite sure yet, but yet I think that would require, for example, having to maybe conduct, of course, interviews with those people from that side of Bolivia, because it's one of the progressive constitution in terms of trying to redress colonial injustices, because it incorporates, it integrates all the foundational values of its people. For example, it speaks about solidarity as a foundational value. It speaks about ancestorship. All those, they are part of that plurinational of that constitution. So it's a really forward-looking constitution in terms of achieving a deep plural legal system and in terms of progressing forward. So,
But is there any other countries like Bolivia that you have found in your research?
no, I'm focusing only on Bolivia, which is
You got a question over there?
Yes, not a question per se. I'm from Nigeria, and one of the, even though our constitution may not be termed as progressive and South African constitution, but with regard to legal pluralism, recognizing, I mean, Islamic law, even customary law, I think Nigeria has that because it's embedded in the constitution. Islamic law, even the application of Islamic law, has its own institution. So it's not like fused into, which is one of the areas which I'll get to in my paper. It's not like it's looked at as a separate system of law that requires its own principle and its own, just the way the conventional law, the way we study the conventional common law, the same way Islamic law too is studied. And we have experts applying it to life situations, and there is its own separate court for it, and then appealing issues up till. So I think maybe you can just take a look at the Nigerian constitution, how the Nigerian constitution recognizes that system, because from the foundation there have been that negotiation, because even though with the Muslim community is not maybe 60-40, is more or less like maybe 50% with regard to even Christianity. But there were some issues that were negotiated at the beginning of the drafting of the constitution. And one of the key issues is recognizing even customary law. We have customary courts. So they don't fuse everything into just one system, and maybe the common law dictating almost everything for the other systems of law.
Thank you for that. Yeah, the problem that I have in terms of achieving the deep, like a plural system is whether are those systems which are recognized by the Constitution running independently? Do they have autonomy, or they are still subject to that one document, which is the Constitution?
Yeah, the Constitution is the supreme law, nobody's doubting that. But the Constitution itself recognizes that we do not practice only one system of law. Islamic law is part of the system of law in Nigeria. Customary law is part of the system of law in Nigeria. Then the issue of choice of law and some other conflict of law, that's a separate conversation. But at least that recognition that this system of law is not just one that's just like in South Africa. I was really surprised that, in 2022, South Africa is just recognizing that Islamic marriage is legal marriage. And I mean, because it's just to make a point to your attention to, even in Africa, we have examples to show that, this constitution recognizing, which South Africa is at the verge of doing with this case right now, is to recognize that this system of law itself has its own principles, its own and should be given that recognition. Then how to then sort out the conflict and whatever, then going in deeper into other conversations entirely. I'm just pointing that maybe you just have to look at in African context examples that you can use to
Okay, thank you to the speaker, thank you to the presenter, thank you very much. Time is run out. We're going to have a quick 5-minute break if possible. And then our next speaker will be Seehaam Samaai, should be our keynote speaker, and we'll have a Q&A after that. So we should have a mini break. Thank you very much. Mohammed.
Are we offline?
Can you mute it?
Oh, yes.
We'll open to you.
Correct, for that, and I mean, I'm normally very fast, but I'm trying to be faster.
Okay.
Because I want to engage with all of you. I like academic settings because it allows you to criticize, even judges. I'm on the non-practicing role, so I can also criticize. So good morning, Mweni, Dumalang, Sawubona. Assalamu alaikum. Friends, colleagues, students, those that are online, respected members of the academia as well as clergy. It's really a pleasure to be here. All you know, you must probably know that UWC is my alma mater, a faculty with deep history of struggle and justice. And I want you to remember that. This is a keynote. Many times I thought of turning it into an academic paper, etc. But this is not the time for that. It's a time for reflection, as the topic says, but it's also time for truth telling, for holding a mirror to our democracy 30 years on. And because the struggle for recognition of Muslim marriages is not abstract, it is not theoretical, really. It's a lived everyday experience in our homes, in our mosques, in our courts, in our shelters. And so I need to be able to, before I start, also just do a personal reflection. My daughter last night, I changed this speech many, many times. And she says, Mommy, in what context am I married? She almost died. I couldn't give her a straight answer. I couldn't. It should have been the simplest of questions. And yet here in South Africa in 2025, the answer is painfully complicated, as you can see. The law is still not fully, don't still fully see us. And I can say us. And every day, this particular delay tells my daughter and all our daughters that their dignity can wait. And I want to place this here because you are the leadership of tomorrow. You are the academics that are going to write, and that's going to bring in what the transformative constitution promised us in 1994. So I saw how the high cost of legal representation excluded poor and working class communities from justice. I saw courts being used as tools of oppression rather than liberation. And I think it's important for me to say that I grew up in a community that was predominantly Muslim. And at a young age, I saw women, how they were treated by the law. I saw how at divorce or death, women married only in terms of Muslim rights were left with no property, no maintenance, no recognition, and on final, undignified, never married on their death certificate. So many had no choice but to accept their plight because of deep economic inequality. And so this is what drove me, firstly, to study at UWC, finish my master's in constitutional litigation, become a lawyer, become an activist, be in a commission now to be able to ensure that change happens for women. And so I wanted to use always law as a tool for social change, but to sensitize the law to the realities of women in our communities. So it was natural when I started in 2016 at the Women's Legal Center, which I left last year, where they launched the case in December 2014. And when I came, it was 2016. And there was a few other cases, which you even know, your own, is a doctor or professor, Farid Musa did the case of N. Musa versus Hanika. And I was also arguing that case, which was, I came in as amicus and argued, side by side with Farid Musa. So there was many other cases that came. And so the application sought to provide collective relief to Muslim women who had been denied the same protections afforded. So this was a conscious strategy of the Women's Legal Center to become a de facto litigant of women who are unable to bring the cost. Because I'm telling you now, it's not easy to go to court for 7, 8, 9, 10 years. You must ask Daniels, you must ask, look at the time frames. And the state opposed the relief on the grounds of preventing unintended consequences. And I want to put this here. We're in an academic setting. Please,
You know, Professor Moss is sitting there at the back. Read this. You will see these are people. It's been 30 years and even before where we have struggled to be able to ensure their recognition. And it's not just about unintended consequences. It's the problem of political will where the ulama is concerned. And so the legislature now bears the responsibility of ensuring the effective redress. We have taken it to the point of the court. The court have pronounced. So where to from now? So proposal to restrict the application of the Divorce Act to Muslim marriages within a limited time frame are inherently, I would submit, unjust, as the exclusion of Muslim marriages from the Divorce Act, as the court has indicated, even the Marriages Act were unconstitutional. We can go deeper in, it was mentioned. So Parliament has addressed this before in other pieces of legislation, which I think is important when you need to look at recognition of customary marriages, the civil, you know, all of the customary marriages amendments, etc. That has all been done. That extension, for example, has positively affected a larger number of couples, you know, and to be able to ensure within the customary setting, if you look at it, how they merged, to be able to look at something similar, which is why the interim relief of the court case was actually based on the recognition of customary marriages. If you look at it. So the Women's Legal Center case submit, I mean, that similar measures must also then be applied to the Muslim marriages. So what I'm going to look at is this presentation is going to look at what you will now term, which is a transformative constitutionalism, the transformative nature of our constitution and the journey, and the implications of the Divorce Amendment Act, which is a significant step towards rectifying the historical discrimination impacted by Muslim women upon divorce, and by granting their marriages legal recognition and equivalent rights as they were accorded to other marriages. And this is obviously in the context. But additionally, the Marriages Bill addresses the legal recognition of the regulation of the unrecognized marriages, including Muslim marriages. And that is still out there. So through an examination of all the legal proceedings, I will try to look at the constitutional necessity and the social implications of these legal challenges, and also submissions regarding the recognition in terms of the Marriages Bill, which is 2023, and the role of the court, if any, and advocacy in pushing for reform. So the non-recognition of Muslim marriages, not just Muslim, Hindu, and other religious marriages, has historically placed women at a significant disadvantage. And I must, you know, the Women's Legal Center has been instrumental in advocating for change. They have been. Culminating in a landmark court case which found that the lack of recognition is unconstitutional and it requires legislative reform. So for decades, women in these marriages have faced legal challenges. The lack of recognition meant that upon the divorce, upon the death, women are not entitled to the legal protections available to women in civil marriages, such as claims for inheritance, such as claims for maintenance, such as claims for spousal maintenance, and equitable asset redistribution, which are key issues that is going to become possibly litigious or challenged post the Divorce Act. And so even with I'm not going to go through the WLC case, but following the Concord ruling, the Divorce Amendment Act was introduced and signed into law. The act allows women in these marriages to initiate divorce proceedings in civil courts, ensuring they do not have to rely solely on religious decrees. Now, this is a little bit, which may not provide equitable relief. A little bit, you know, challenging. Do you require a talaq or fasaq before you enter the courts, etc.? And we need to be able to look at these provisions and what the Divorce Act says in relation to that, and under what circumstances, because we do know that many women can be months before the decree of divorce is given in a fasa. Even the person could be abused, but they will go through a process of 3 months, 6 months, 8 months. And so is that sufficient for a court, a secular court, to be able to, without that decree, to say that's sufficient to be able to ensure that there is a divorce, because it's got to do with the estate. So the bill's purpose is to amend the bill, but the Divorce Act was to ensure there's the insertion of the definition of a Muslim marriage and to provide for the protection and safeguards, in particularly of children, to allow for forfeiture of benefits. And we'd like to get your opinions around this. And I'm still going to say, it's not just constitutional, but it's also, for me, in terms of the fiqh, Sharia compliant. Let's just place it there, drop the mic, deal with it. Let's move forward, because we need to be able to, 30 years on, ensure this codification. The legislative changes have profound impact on the lives of women in unrecognized marriages. And so this marks a significant advancement in the quest for substantive equality and the protection of vulnerable groups. So the Act allows persons who are in these marriages to get divorced in terms of the law, and it does not constitute or replace, for example, a religious divorce. It doesn't possibly. Not. I mean, there will be arguments, but at the end of the day, there needs to be an end. The abuse has to stop. And if it's not going to happen at the point of the Sharia court with an ulama, etc., the court has to come, like he has done over the past 30 years, to the protection of Muslim women. And so the committee, we need to discuss this also. There was also the regulation of a registration of Muslim marriage as well, which came in with the Al-Jama'ah Party, which was just before the Divorce Act. That bill was pulled, and it only dealt with the registration. So there's much confusion, because people are still thinking that you can go to the Home Affairs, that Muslim marriages is recognized, and that they are actually getting married in terms of whatever that law is, which doesn't exist. It's actually done in terms of the Marriages Act, which does not recognize polygamous marriages. So it's still the old system. And so we need to be able to look at that. So the South African reality is our constitution is a beacon. It enshrines equality, dignity, freedom of religion, access to courts. But let's be clear, the constitution often says more than our law delivers. And so South African Muslims do enjoy freedom of religion, but beneath that surface, the question still persists around the particular recognition. So let's step back again for a moment. 2022, Constitutional Court declared the non-recognition of Muslim marriages unconstitutional. 23, the court reaffirmed it. Women cannot be left invisible under the law. 2024, 2023 comes in December 2023, divorce. 2024, May, Parliament asks, you have the Divorce Act coming in. Then Parliament asked for an extension, because the court case indicated 2024, June, that everything had to be finalized. Extension granted till 2026. It passed the Divorce Amendment Act, which gives partial recognition, access to divorce, etc., etc. Today, in 2025, we find ourselves with a marriages bill. And I think that Professor Mosa, I don't know how many, does it other? Fourth one. It promises a unified framework for all marriages, but let us be honest, we've had many versions of the MPL bill before, and none have come to fruition. And so the Al-Jama'ah, there was, like I told you, bill was also withdrawn, and we are still awaiting. And so 1 year away from 2026, which is also what Dr. Terblanche have raised, is that Muslim marriages remain only partially recognized. And we're still sitting about, what happens to her rights at divorce, what happens to her security at death. These are the academic questions. What is the legal status of a Muslim wife? And so the development in the law, even though the Amendment Act deals with marriage bill, for example, interim relief, also redistribution of assets, etc. And there was a High Court case which dealt with, in particular, the interpretation of the interim relief, because you all probably know that that is the new argument that is out there around, can one have interim relief when the talaq was given possibly a year ago? You still have maintenance because you know that the talaq, you know that the period is only 3 months. But the other issue is that this woman is 65 years old. What are you going to do in relation to that divorce? This is the lived reality. And I'm not just making it up to make the facts dramatic, but it's true. And the court, which the court then indicated in this Rule 43 application, that the law will not allow pronouncement of talaq to leave women completely destitute. No. They differentiated from prior cases and they indicated that there was a continuation and the Rule 43 maintenance still applies. So the challenges, let's name it. There's many. There's still going to come a huge amount of fights. But I hope 30 years on that at least this one is going to go through. Muslim marriages remain waiting, and I submit that the recognition delayed is recognition denied. The fragmented reform breeds inequality, and women are forced to navigate civil, religious, and customary systems often at the most vulnerable moments. And let us not speak about the children. And I'm glad that Advocate Shireen, you know, that the family advocate was online. Because what we do need is to be able to ensure every time that, because in a normal civil divorce, you have, it needs to be filed at the family advocate to be able to ensure the contact and care of the children are taken care of. That divorce being served on the family advocate. Because we know in a civil divorce, and I love that family dance here, can you see I still know my divorce law? I know it. I know my annexures, A and B. So I want to know whether or not the ulama is going to complete that A and B. Let's leave it there. Because there's a lot happening. Because there's a reason why that is being served on the family advocate. And then, let's be unapologetic. Our ulama cannot remain silent. Too little has been done to demand that the marriages bill be passed. Leadership requires courage. And courage today means standing with women. And I'm speaking to the men here. You are the one that is going to, you know, not rewrite, not innovate. Don't worry. I won't let you go straight into the what's name. Okay, not make jokes like that. But the point that I'm trying to say is that you need to be able to change and use and distinguish between the fiqh and sharia, to be able to understand how you can use the tools to be able to ensure that women are protected. I'm not going to say change, but to bring in those aspects of Islamic law. So let me just leave it here around, let me speak about it, because the fiqh of minorities. I want to pause here and reflect not only as a lawyer and an activist, but as a Muslim woman. Also, what was just said by the erstwhile previous speaker in his paper, I'm talking about Dr. Terblanche, is that how do we reconcile our constitutional struggle for equality with our religious traditions? The answer lies in what scholars, and I'm going to place it here, because I do think that it is a mechanism and a way for the ulama to start looking at the framework separate from just what was indicated. Is it compliant to Sharia? Is it not? Etc. The answer lies in the fiqh of minorities, I would say. It is a discipline of Islamic jurisprudence developed precisely for Muslims living in non-Muslim majority societies. And so I'm talking about your Bolivias. I'm talking about your Argentinas. I'm talking about your South Americas. I'm talking about your Australias, maybe in your New Zealands, etc., where there's some minorities. And what does that look like? What does the fiqh of minorities look like? Why? Why am I doing this in South Africa? The principles of Sharia must be understood in the context that the higher purposes of the law, which I think all of you, why I know it, because I went through exactly the same course that you have, which was around the higher principles of the Sharia, which is Maqasid al-Sharia, which speaks to justice, it speaks to dignity, it speaks to welfare, and it speaks to the protection of families. And so that the tools of ijtihad, independent reasoning, urf, the local custom, must be used so that Muslims can be both devout believers and responsible citizens. And so the scholars of this discipline, Qardawi, remind us that protecting Muslim women from invisibility of the law is not against Islam. It is demanded by Islam that our women must be seen. Because what's at stake here is not ritual, but rights. Not form, but justice. And so when we demand recognition of Muslim marriages in South Africa, we do so not only as feminists, as gender activists, not only as constitutionalists or academics, but as Muslims guided by the Maqasid al-Sharia. And so, and I say this clearly, the denial of recognition which leaves women destitute after divorce or vulnerable after death is not Islamic. It is a failure to live up to Islam's deepest commitments of love, compassion, and about dignity. So I'm going to merge it now with a feminist reflection on intersectionality, because a court through this transformative vision can merge and ensure that we all live in harmony. Intersectionality, which was obviously coined by Crenshaw, but I do believe we spoke about intersectionality possibly before Crenshaw, but this is now the theories. And it reminds us that oppression needs to be able to be looked at in terms of different levels. So we are not only women, but we are South African women. Part of Africa, part of the global nation, but also about being a Black woman, about being working class, shaped by our histories of race, shaped by our histories of class, of apartheid, which is why context is so important. Because women in South Africa, firstly, of their gender, could not own property. We know the Marital Act only changed when now, 1984. You could see, we could never, so layer that with race, layer that with marital status. You don't just get a triple oppression. You get much more if you're a Muslim woman. And so example of what we need to ask ourselves is why Muslim women don't have their own property or land or even dowries that take this into account, because the vast majority, we see what's happening in our courts. And so the recent case also, which was handed down, that was brought by the Women's Legal Centre and handed down by Judge Fortuin in the Western Cape High Court, relating to the city of Cape Town, and them not transferring the property to Muslim women. Even though those women were surety in most of those cases. It was on the name of their husbands because of the sanctity of contract, Professor Mercer. Sanctity of contract that caused that hundreds of properties that was given to women after 1994 by the city of Cape Town was not transferred to them. And we had to go to court. And Judge Fortuin indicated unacceptable, unconstitutional transfer. And it actually forms part of a divorce now. You can see it as that. So so for Muslim women, it is also carries the compounded histories which apartheid places on them. And solutions can't be one-dimensional, and they must address the interlocking systems of oppression, racism, inequality, as well as religious marginalization. So I say that intersectionality allows you, and transformative constitutionalism, with the broad concept of minorities, blends with our Sharia and also our fiqh, maqasid, ijtihad, urf. Justice for women is part of Sharia. And the intersectional approach gives us the constitutional and legal tools to argue for justice, because together it says recognition of Muslim marriages is not a favor, but it's a constitutional imperative as well as the Islamic imperative. Many scholars and academics, organizations like Women's Legal Center, and I would say now, and we have to admit the Commission for Gender Equality, the Chapter 9s, the Human Rights Commission have all been on this journey. But I must also pause, and then I'm going to end, because the women who came before us, and we need to be able to honor them. We need to honor Daniels, Mrs. Campbell, Ms. Daniels, Hassan, Begum Hassan, Rylance, Ahmad, Khan, Hussein, Rose, Farouk, Isa. These are women. They have gone through 30 years of trying to develop this MPL. This struggle has many faces and many names. And I want to place it here because this is 1 year after, 2 years after 2022. And behind them are lawyers. Let's recognize people that have passed on, people that are still here, judges. Soraya Bosch, Chantal Fortuyn, Michelle O'Sullivan, Sibongile Ndashi, Nikki Naylor, Huda Faker, Jenny Williams, Fatima Mohammed, Nasreen Bauer, and many, many others. The Legal Resource Center, the Women's Legal Center, CGE, all they built feminist jurisprudence, MPL, brick by brick. And then our academics. Professor Najma Musa, Fatima Sidat, Wahida Amin, there are many. And I think as a collective, we need to be able to see how we can bring this to an end. The act needs to come and to be able to see how this journey of blood, tears, sorrow, joy, love, and resistance is not, it's not an end in itself. It is the beginning, and we need to be able to see how is it that we can bring in changes for women. It did not begin in 1994. It stretches way back, and it will continue. And so Parliament must act. The Marriages Bill must not remain a draft. It must be enacted, and it must be just. Judicial oversight remains essential, and it will continue to be there to prevent abuse and also abandonment. Religious leaders cannot be silent any longer, and women must lead. Advocacy in education must continue, because women, and we want these papers to be written, because it's these papers that brings about change. So when my daughter asked me, Mama, in what context am I married? My answer is, for now, my child, you are married in terms of Sharia. You are partially recognized under civil law, but I will not stop fighting until you are recognized fully with justice, with equality, and with dignity, because this is not simply about the law. This is about democracy. This is about dignity and equality. And 30 years on, the unfinished promise of democracy is a woman. No marriage, no child should remain invisible before any law. The time for delay is over, and the time for courage is now. Shukran, tamakasi, thank you. And what I'm going to throw out to you is, what does it say about our democracy? Can a democracy be complete if some of our citizens remain invisible? Do our current reforms truly deliver justice? And in 2026, when the Constitutional Court's deadline arrives, will we look back with pride, or with regret, or with another missed opportunity? Because hectic, we cannot go on another 30 years. And I do not want to represent another woman in court interpreting what Sharia says and how it protects them. If it's a divorce, it must be a normal divorce, and we move on. So shukran for that. If there's any questions, okay.
Thank you very much for that insightful dialogue. I'm going to open the floor to some questions.
Shukran, Ms Samaai, for that very enlightening talk. I apologize, I had to leave for a brief moment, but I rushed back, I can assure you of that. Your lecture was very enlightening, and I just want to ask you something that's pondering on my thoughts as well, that I'm rather pondering on. I think your indie remark you made over there was profound, and the build up to it, obviously, it has a very good basis. But my thought process is, if you're going to advocate for the civil divorce process to be followed throughout, you can correct me if I'm wrong, but a blanket approach, apply the civil divorce process throughout. I understand your rationale, I understand your reasoning for doing this, frustration and so on and so forth, and many years, obviously Musa can attest with as well, and many other academics. But don't you think that would be a two-edged sword? Why I say so is because, as we know, our civil law is gender neutral. When I say it is not, there's no mention that, as opposed to Islamic law, where it says the husband needs to maintain the wife. Our civil law says it's dependent spouses to maintain each other in accordance with their income. It's proportional to that. And I just had a chat with another magistrate, senior magistrate recently, who was also conducting a PhD at UWC. And the issue that they're facing is what men are doing, not necessarily Muslim men, but okay, I actually can't say the demographic. What they're doing is they play around with the legal system to the extent that they'll quit their jobs for a few months before the divorce, and then they claim maintenance from the woman. So, I mean, that's well known. Some people look like they're a bit shocked about it, but that's what happens in our civil legal system. So, if you are advocating for a civil divorce throughout, I don't think it will have a knock-on effect or two-edged sword, in my opinion. What is your comments on that?
I'm gonna, you know what, I'm going to go with the broad concept of again, about the fiqh minorities. The challenge that you're sitting with is that we are not in a country, obviously, where Sharia is dominant, and we need to be able to ensure that whatever happens here in terms of the citizen, that it doesn't fall below in terms of the constitutional rights, but also doesn't go against what the Sharia or the fiqh, etc. says. So it's almost like on that boundary. But in South Africa in particular, there's a lot of decolonization that needs to happen also in terms of processes. So if you are going to look at it, obviously you're looking at it, if you look at the entire civil process, from a purist perspective, this process is not Sharia compliant, because it's many things. If you just take out, for example, a redistribution, you take out the issue of only these issues are not part of Islam. You know, you can't have redistribution, it's by nature out of community property. But place that in our system. And let's speak about this gender neutrality, whether or not it's really, you look at it linearly between male, female, etc., etc. No, it's not actually supposed to be gender neutral, but leave that. I'm just saying that you can't place the Sharia completely, it's a system, and you must probably know. You can't put the entire system possibly in here. And you are trying to be able, so we are saying in terms of this, what in this can be developed to be able to ensure the protection of women, but also as an example of how it can merge with Sharia, with fiqh, and develop that fiqh of minorities, and to be an example, not just in terms of South Africa, but also in terms of other countries, of how you can merge and how we can live. Whether or not you say that there is no difference between the constitutional imperative and what the Sharia wants for women, or whether or not you say merge, or whether or not you say live side by side, the issue is that it's not going to be opposite. You're not going to get your perfect system. So you need to live with that. And what does that mean for women at the end of the day? And I'm trying to center women, because in terms of the entire system, and I'm not going to say Sharia, I'm not going to say the fiqh, I'm going to say the application of the Sharia, the application of the fiqh in this world, and also even our not secular civil system, all disadvantaged women. Because patriarchy sits in the center of that, and we need to dismantle it. And so we need to shift. We are not going to find that perfect system. And we need to be able to develop what does that mean for women and for Muslims in South Africa, and continue on that. Because if we're going to do that, we are never going to have Muslim marriages above. We're not going to. Because we're still going to have the arguments around the school of thoughts. We're going to still speak about the North and the South. in terms, no. We need to be able to center something and to be able to see what does our constitutional speak to in terms of women, in terms of gender equality, and in terms of ensuring that they get the benefits of this constitution. So I'm not answering, I'm just saying, don't go down that path. We deal with what we have.
I 100% agree with you on that. There's never going to be a perfect system. We can't, like I said, Dr. Dawood earlier in his keynote as well. I don't see a potential of reconciling the two systems perfectly. There's no such thing as perfect. And we as Muslims believe that our first thing, there's only one being is perfect, and that's it. No system is perfect besides the system of Sharia. But in our South African context, we have the imperfections of the lack of enforcement. As you mentioned earlier that balanced constitution and Sharia borderline. My question still raises, I'm not trying to approach it. I'm just trying to think practically about it. And I mean, I'm doing my doctoral research on this topic, and that is why I'm so intrigued by this question. And I'm asking practically, if you're saying that we shouldn't go into this question, then how do we practically find a conducive answer? We're never going to satisfy everyone. What would your answer be then? A practical solution to at least meet the minimum criteria of both?
I'm saying develop the system that is now being given to us to be able to ensure that we'll be able, it's not going to be perfect, but to be able to infuse, just like law is there to be able to interpret. And I think that we are in this, and I'm not saying don't write about it, do it, etc. But to be able to come back to something when it comes to South Africa. And what is that something? We need to gravitate towards it. Maybe your doctoral thesis is going to say, this is the something that we need to gravitate towards. I'm saying, pick a minorities, a Makassid approach, using what the doctor was saying, but also use intersectionality when you make the decisions around this particular case to have an outcome that actually protects the dignity of that women and children. That's what I'm saying, because the court is not going to, I'm saying when you're in the court system, I'm saying use that three to be able to come to some form of solution and not have is it Sharia compliant or not.
Can I just add to that? I think another frame really to work with on that is they call it fiqh of priorities. The fiqh of priorities. I think this is probably where we could also land the conversation or what are those particular real needs of the Muslim community, you know, where people are really suffering. So if we are able to identify, you know, those particular areas and put some sort of concentration on those things, we should be able to at least give that particular attention, you know, to part of it. We won't be able to get the full sum of it. But the figure of priorities is another very interesting, you know, discussion. So if we are identifying with the system that we are currently in, where the sufferings are already taking place, and we are identifying, we're acknowledging it, and we're accepting, let that be at least a start point to activate this particular conversation and meet perhaps each other somewhere, you know, because it needs to happen. What that looks like is where the debate needs to happen here in the room.
So, with the women and children, with the children aspect, I mean, obviously, the father was not against the guardian, so ideally the children should at a certain stage go to the father. But the reality of, I think, globally is that the children remain with the mother. So on that basis, the Sharia will not protect the children. Should it not suffice that he should be maintained, make sure the children are housed and so forth. So just some clarity as to what are the difficulties that the children face. I know at Home Affairs it's a bit problematic because in terms of the Children's Act, if you're born of a religious marriage, it's child-born and married parents, but Home Affairs has sometimes its own weird rules. But then with the women, when you speak about the interim maintenance, obviously, I think that is probably a very big problem as it comes to an end of the Ida. How would you, but now with the 65-year-old, who probably doesn't have a father, maybe doesn't have brothers. So when again, it's again tied to the question that I have, when we say that Sharia protects, how does it protect such a woman? And so I can understand why we may be looking for solutions in civil law, but then where do we tell that now?
Yeah, but if I'm saying Sharia does protect.
But how?
But like, for example, if you look at also the issue of maintenance, which I didn't touch here, because the Sheikh said I mustn't. No, I don't. I also submitted my thesis, you know, in maintenance, looking at through a lens of Makasi, but in particular in Cape Town, which I do think that sometimes Cape Town with the MJC, etc., here, we tend to have a little bit of different ways. You know, in terms of different types of interpretation. But with regard to maintenance, even if you say the Sharia doesn't, but this particular Divorce Act actually deals with maintenance. It hasn't dealt yet with spousal maintenance. Okay, the children is not an issue because the Children's Act deals with it. And now the Divorce Act, and we know in terms of compliance, and the family advocate is very clear now in terms of their standard operating procedure, that talaq or that divorce application, the summons must be served. And so my difficulty is that what if you have those that is not issuing those summonses? Because remember, it only gets done when the summons gets served with that document and it gets served on the but also our court don't look at the genders and the interests of the parties. It looks at the interests of the children. And we know that that has been developed in terms of what is required. And I think that whatever those issues are that they're looking at in terms of children are also issues which Sharia looks at. Because if you have a woman that is still breastfeeding, still looking after children, etc., you need to go beyond the 3 months. That is in terms of breastfeeding. There are rules, but it's rules that people don't take out because they don't want to. It's not that Sharia don't say that you can go for me beyond 3 months. 3 months is not the pinnacle of this is it. No, it's an interpretation of a school of thought, and there are many school of thoughts. And I'd say that for me, the best of those school of thoughts need to be able to be interpreted to protect those women. That's the way we were, you know, we can change in terms of that, but leave the school of thought. I'm saying it does allow. And so the Divorce Act allows for spousal maintenance, I would argue. Secondly, if you look at it from a Bakasi, you can go beyond. And also, if you look at international law, which I think in India, which is a Shah Banu case, which obviously you could see when it went up against the clergy, they ended up changing the legislation. We don't want that. But I say we can learn from the Shah Banu case and to be able to use the same and to be able to say spousal maintenance need to go beyond, or we must just legislate. If you're over 60, you've never been married before, you don't have, why can't the law then say to whatever it might be? So that you can live in dignity because your husband, you don't want to be a second wife. And I think fundamentally for me, it's about the choice. But even if you want to be a second wife or a third wife, currently, let me tell you, you can't go to Home Affairs and go and register the second, third, and fourth one because the Marriages Act don't allow for polygamy. So the changes must come. So who protects the Hassams? Who protects those that are, for example, in the Boersa Hanukkah? Who protects them when it comes to the second, third, fourth one? I'm not concerned on whether or not the international law at this point allows polygamy or not. That is a change that feminists need to take on for many, many years, and we will change. But at this point in time, there are still women that want to be second, third, fourth wives. And the issue is that how do you protect them in relation to that particular divorce? That's going to come. Unless that marriages bill is going to be passed. Because what's happening now with Home Affairs is not constitutional.
I know I got very late in my, I was very interested, especially at the topic that we actually at right now of South African Islamic court part. With Islam, I'm not a Muslim, right? But then I am a very traditional woman. I agree with polygamy, and in which that is where we find the center with April. But then here's
in whatever thought that we have, or maybe if the Islamic code comes about, or we have that, how are we going to avoid it being like the traditional codes that we actually already have for traditional marriages? Because also the Marriages Act, they just include us as traditions, or whether Islam, whether lobola and whatsoever, we are included.
Yeah.
But then the system still imposes something on us as if we do not exist. My question is, until when will we be included by systems that were imposed on us? Because I feel as academics sometimes, or as legal practitioners, we always want to say the law is like that, but the law is not correct. So how it comes to rejecting the whole entire imposed, because you recognize that there's an Islamic marriage, but then when you go for divorce, you need the High Court. For that divorce, you need, and for you need the High Court because at the end of the day, you need a marriage certificate before, and you must apply to the High Court even before you want actually that divorce from that marriage. So there's some sort of inclusion for exclusion within that whole system. So how are we to avoid that? Because to me, whenever I look at Islam, I look at it from the point of tradition as a whole.
Yeah.
So,
Well, I can give you a practical answer. Maybe you can ask the lady that's sitting at the back there. She drafted many summonses. Tell her to draft the summons, that the Islamic summons, the things that need to account. Now, what I'm saying, okay, you are correct. But I have to say that over the past 30 years, the court has come to the assistance of Muslim women. And you can't say that it was, for me, an Islamic in terms of what they wanted to get for those women in relation to the non-recognition. For example, Daniels, Ahmad, for example, it was a motor vehicle accident, and they didn't want to include Musa, the Wills Act, the first wife, and all of it. And so you could see the piecemeal way of trying to give protection. So you can't, like, it's not that the law was it was the interpretation of it, and to be able to give protection because you weren't even seen, you weren't even there. Yeah, okay, which is why the maintenance of surviving spouses, all of those you had to be read in.
Yes.
Okay, so now we don't have the reading in, we got the marriages bill now that looks at all of those things. Sometimes you would say yes, superficially, because it doesn't go deep in, but we need a broad framework to start somewhere. And my issue is that we can't go to the extreme part of saying Sharia, we want to live in our, we don't live in a constitutional free zone. Oh, Judge, Professor Mosa, maybe one day you will write about that. Eh? I'll write about that. That was an argument of the state. There's a constitutional free zone where you can operate. No, there is no constitutional free zone. You can't have children, for example, under 18 getting, these are things that is going to be legislated. There's a constitutional dispensation that we need to be able to adhere to. And so that's the framework. It's a constitutional state.
Yes. If it is a constitutional framework, like we say, what about the rights to traditions and everything that is being promised? And here's the thing, the law is supposed to be just like Constitution promises all of these rights to the people. Isn't it also the fact that we have to be let in or whatsoever, isn't it also a constitutional infringement within that? Because whose rights are these that we are protecting? That constitution, that Marriage Act, whatever act, is not law that the people recognize. And we want that law to govern them, over them. Isn't that a constitutional infringement on its own? It means that whole entire act is actually, it's working outside the constitutional framework itself, though it is constitutionally recognized legislation or adopted. So, like, why is it that, because all of these bills or acts that we're talking about, we need to be honest,
There are acts that were left with us in South Africa. The acts that we inherited them. But then we said that we're having a constitutional dispensation. But then what constitutional dispensation when the rules that oppress the people still continue to be imposed on the people? What constitutional, this thing of constitutional framework is very subjective. Because what law are we, what is this constitutional, transformational constitutionalism that we're talking about?
Transformative constitutionalism was written about a lot.
Yeah. So
No, I think it's aspirational. It's aspirational, and to be able to know where we all fit in as women, whether or not it's Muslim, whether or not it's cultural, etc. Because, and I know what you're talking about, the Sharia courts. For me, I mean, it's not going to happen. So you can have a Sharia court, but the challenge that you're sitting with is that we need to be able to look at the system. For me, and I am biased. I'm biased towards women. I am. I'm unapologetic around that because they are the ones that were, and even that system that you're talking about, the customary system, the religious system, traditional religious system, traditional custom, oppress women. No land, no maintenance, rule of primogeniture. We know Gumedi, we know Kutwala, we know under 18 getting married, we know all of those things. Legitimacy, illegitimacy is still in our is still in our customary. Yes, still evictions happening in when the person passes, which means the rule of primogeniture still applies in practice. Can't be. Way back already, Gumedi, Daniels, all of that changes to be able to uplift the women and to be able to ensure that that constitution, which you say has no framework, gave exactly the rights to those women. It gave it to Daniels, which allows her to inherit. It gave to Gumedi. It gave to all of those different women rights that they were never had. 1994, no rights. You could get divorced. You could be thrown off your land. You had no recourse. Go back and read about the rule of primogeniture, because it's not just in your custom, it's also in your religious laws in terms of who owns that particular property. So, and those issues need to be dismantled. We cannot in this day and age be apologetic around systems in custom and religion that oppresses women. It doesn't work.
I think she also probably say that we are talking about the colonizing laws.
Yes.
Like the Civil Marriage Act was imposed on all South Africans. But that's where you go.
That's why we know that the Marriages Act, the current one, they acknowledge that it was a Western Christian type of, no, we acknowledge that. Which is why if you read at the beginning of the current marriages bill, I'm not saying it's perfect. Then I want you to go to section 6, because that is going to be oppositional, because it says in there, I'm going off, but let me just tell you something. Section 6 says that you don't need consent as a second or third wife, etc., in the particular provision. Go read the section. Only you need consent. You don't need consent if you come from where? The royal family. And so read the provision in the marriages bill and see why it will not be able to get through constitutional muster if they don't allow the second wife in the royal court to be able to also get permission to read it. That's one particular section that will throw that entire marriages bill out, not even based on religious, but based on custom. Only one party has to ask, not ask for consent. So I think those are the type of things through a gendered and feminist lens we can't allow.
Unfortunately, we're going to have to stop there due to time constraints. We can take this conversation a bit further later on, but just to keep with everybody, I think we have to wrap up. So thank you very much, Seehaam Samaai. We have to move on to our next presenter. You can come forward. Oluwatosin Adegun will come and present need for a South African Islamic court to adjudicate matrimonial causes arising from Islamic marriages, Kenya and Nigeria as case studies. You may please have a seat. Yeah, we come to the end. Okay.
Yes, good afternoon. My name is Oluwatosin Adegun. So I'll be considering the need for a South African Islamic court for adjudicating matrimonial causes arising from Islamic marriage, and Nigeria's case studies. Let me just go straight to the point. Looking at the decision of the Constitutional Court in the Women's Legal Center Trust versus the President of the Republic of South Africa. On reading the decision, I have a couple of issues with it. The first issue I have is the fact that the existing laws on marriage and divorce, I mean, like the courts just cramped the Islamic marriage without really understanding. I don't think the court really analyzed what even Islamic marriage is about, what Islamic law system is about. So the courts just do plus minus and just cramped, the Islamic marriage into existing law meant for civil marriages. So can that actually really work? And the second issue is regard to institution. The existing institution of adjudicating marriage issues, matrimonial causes issues, can they really deal with matrimonial causes that arise from Islamic marriage? Those are actually but before I actually go into the depth of that, the fact of this case actually raised important issues. One of which is, if we check paragraph 9 of the judgment, you'll see that there is a kind of the non-judicial dissolution of Islamic marriage, which, like in that paragraph 9, there is possible lack of fair hearing, especially for women, as evidenced in the Faru matter. So in Faru, when the husband went to the imam to say, oh, the talak, the procedure for talak, yeah, I've divorced my wife and all, I found it very problematic that, and the woman was pregnant at the time, so there was no opportunity given to her. The imam even given the certificate of talak did not even know she was pregnant, and not even when they reconciled, he had no idea. So there is kind of a gap regard to in terms of the protection of women in non-judicial Islamic dissolution of Islamic marriage. Then it also happened, the back and forth with the inheritance thing, the daughter to the deceased person going to the institution to say, the Islamic institution to say, oh, this woman, she had already divorced this man before he died. Then they made a decision. Then later they changed it because another person came to say, that wasn't what happened. So a lot of back and forth. So meaning for non-judicial dissolution of Islamic marriage, there is a problem in regards to protection of women. Then, and by the time the court then gave its decision, the court did not really understand that the existing law, the Marriage Act, the Divorce Act, they are not really tailored for Islamic marriages. And why did I say that? Because if you look at the law governing Islamic marriage, so the primary sources of law, the Quran, the Sunnah, and there are also some jurisprudence, the schools of thought, meaning that, and one of the things that stood out for me with Islamic law is the flexibility in terms of when issues happen sometimes, and the Islamic scholar, whoever is, adjudicating the issue, even if the issue doesn't fit into existing issue that had happened before, there is that ability to, to uphold justice, looking at the facts of the case and establish, principle that can also be used in other cases. So I find that in true sense, the Marriage Act of 1961 of South Africa, when that act was enacted, did not have Islamic marriage as part of the marriages it wants to govern. So in terms of even the history of the enactment of this act, Islamic marriage is out of the purview of this particular act. Then in even looking at the way the provisions are, the procedure for marriage in the Marriage Act, for example, you'll see that except you just have to be doing a lot of plus and minus, then before you now say, okay, maybe this one is maybe relevant to Islam. So as far as for my own research and in answering my own question, then I have to look at it that really, if we really want to look at the justice for recognition of Islamic marriage in South Africa, the truth is the court in, I think, paragraph 82 of the judgment says that it is reasonable and effective to import the Islamic marriage into existing Divorce and Marriage Act. But I don't think it is reasonable and effective. And why I do not think it is reasonable and effective is that, first, these two laws were made even when Islamic marriage was not even recognized as a legal marriage in South Africa. And meaning that those two laws, they didn't have Islamic marriage, the intention of the legislature, Islamic marriage is out of it. Then the second reason I think also that the two laws shouldn't, the court shouldn't have, imported it's Islamic marriage and the matrimonial causes flowing from Islamic marriage are governed by different principles established in the Quran and the Sunnah. That different principle of law that govern this particular. Then another reason is that the customary law, when by the time the customary marriage got its own recognition, there was actually a separate legislation for it. So then the thinking is, why didn't the courts see that? So why didn't the courts import the customary marriage into existing civil law legislation? But the parliament actually made a separate legislation that govern customary marriages. So in terms of the equity of it, if that can be done in the case of customary marriage, I think also the same should be done in terms of Islamic marriage. Then the third reason is that the court system, in terms of the composite, because the court that has jurisdiction to even adjudicate divorce or the civil law divorce, the divorce under the civil law is the High Court or the Magistrate Court. And if you look at the composition, the qualification of the judges, do they even understand? The kind of qualification does not require whether they are even learned in Islamic law. So looking at Nigeria, for example, in Nigeria, Section 4 of the Constitution actually gave kind of divides how parliamentary function between the federal and the states will be. And that Section 4 then leads to what we call the second schedule, Part 1, Item 61 of the 1999 Constitution. And it says, I quote, that the formation, annulment, and dissolution of marriages other than marriages under Islamic law and customary law, including matrimonial causes relating thereto. Now, this particular item is that the federal legislature, because we have this federal system, so the federal legislature only has the power to make laws with respect to civil marriages. But when it has to do with Islamic marriages and customary marriages, it is within the legislative competence of the state. That is like what we call province in South Africa. So, and states do make laws, and how they do it is they enact, for example, in Abuja, for example, there is this Area Courts Act of, I think, the last one that was amended was in 2010. So this Area Courts Act in section 15, as it says that an area court shall in civil causes and matter administer Islamic law of the Maliki School of Jurisprudence. So each state, depending on maybe the community of Muslims in that state and the school of thought or the school, the Islamic school of thought that they tend towards, in those legislation, they have actually created and explicitly provides that, oh, this particular, when it has to do with the Islamic personal law, this is the school of thought they want to tend towards. Then in the same court also, this area court also has, the power to even adjudicate on guardianship according to Islamic law. So the Nigerian context actually gives the view that it is possible for, indeed, if you want to say legal pluralism, so it is possible for the different systems of laws to actually coexist in a country. And that is actually what happens in Nigeria. So in Nigeria, for example, you have, with regard to marriages or divorce, you have the civil marriages, which is governed by the Marriage Act. And the Marriage Act does its own thing, regulates civil marriages. The only thing with reference to Islamic or customary is just in the act is just with regard to, oh, because of the monogamous nature, that you cannot have a pre-existing marriage anywhere, then have a marriage under the act. That is just the only time it's referenced Islamic or customary marriages. But with regard to Islamic and customary marriages, different system of law govern those ones. And how they go about it is the creation of the court system. So there is separate court system that governs Islamic marriages. There is separate court system that governs customary marriages. So if the husband and the wife, if they got married under Islamic law and they want to go through the judicial part of so they just go to the area court. Some state call it area court, some call it cadis. And the same also with Kenya. Kenya is not even a federal system, but in their the last marriage they had to create that system where Islamic marriage is recognized and there is an institution separate, which is a Cadiz court, to administer that. Then the question, which has been kind of that I highlighted during the discussion, is also how the balancing of Islamic law with maybe human rights, the constitutional provisions and stuff like that. So reason why I advocate for a separate court to administer matrimonial causes from Islamic marriage is because if we are to toe the line of Nigeria, for example, the Qadis or the Grand Qadis that are that administer or preside in this courts, they are actually qualified in both common law system and Islamic law system. So they are, I mean, in terms of like well-grounded in Islamic law, and they are well-grounded also in the conventional law. And they are well-grounded also by implication in human rights and whatsoever. So at the beginning, if we really had to look at it, like what happened in the fact of the case that I found very problematic, two things I'm proposing is the reason why we need a separate court composed of judicial officers that are grounded in Islamic law and are grounded in conventional law is to be able to balance because when there is then conflict in the principle of Islamic law and maybe the constitutional provision of equality and stuff, because of their knowledge and the rest, they can be able to balance. And why that is important for us is also for to develop the jurisprudence of Islamic law itself and how it fits into the modern day, the feminism and the rest of it. Because Islamic law, one of the things I found very interesting with Islamic law is the flexibility and how it has developed over many years and still developing. So it's something that I think will really help. And I think with the engagement with the parliament on the Islamic marriage bill and the rest, I think it's one of the things that should be put on the table as well, so that we would not still be, I mean, roaming in the same on the same spot, and I am expecting different results, because the institution that will even administer these issues is very important, and the composition, who are the people, the qualification of the people that will be administering, you know, these issues is so important. Just like it's been said, like the person's very knowledgeable in Islamic law and knowledgeable also with contemporary issues on feminism and human rights, can be able to do the balancing than someone that is only knowledgeable in human rights. They can't do justice to any issue that comes with, but it has to be people that have both qualifications and can actually be able to do justice to any case that arises from Islamic marriage. I think, yeah, that is all for my presentation.
Thank you very much. Any questions, please? You can go ahead.
That was a great association. And I want to know how long this Nigerian system has been in place. And has it been working for the people? If it has been working, and can you highlight some improvements since its implementation?
It's been working, I mean, like it's been in place, like this our constitution is since 1999. So even before the 1999 constitution, we had like the 1979 constitution, which still mirrors what we have in the 1999 constitution. So the thing about Nigeria's context is that from the beginning, it's been acknowledged that it's not only our legal system does not only comprise of the common law, it also comprises of the customary law and the Islamic law. So from the beginning, it has always been like that. And it has really helped because we rarely have conflict, because people, if you've already submitted to Islamic law, even when after your death, and they know that, oh, this person's personal law is Islamic law, there are rules on division of estates according to Islamic law, and there are judges, because even in Nigeria's educational system, legal education, Islamic law is part of it. So we have people that actually go to the university. In the university, they study Islamic law and they are being even appointed as judges in this court. So it's a system that has been entrenched in Nigeria, and it's a system that which I think that has really worked, because it has made it not, we don't have any conflict with, if you want to do civil marriage, good for you. If you want to do customary marriage, it's just that the only issue has been the attempt at some point to place civil marriage over Islamic marriage or customary marriage by, for example, in embassies, for example, they will say, oh, you have to have a marriage marriage certificate. And most time people do nikai and everybody just take pictures, you eat and you go. So then they start, running out to get something to show that indeed. So that is one of the lacuna I see. And it's because people just have assumed that, yeah, it's a legal marriage. If I say it's just that then by the time you do travel, then all the issues then start, then people then, but in terms of the legal recognition, institutions to Nigeria has, and it's really worked for the people.
Quite a number of questions. We're gonna go to the gentleman.
Just to add on to what I'm doing the same work. So we say that for the success of the system that is implemented in Nigeria, we say that the one advantage is because of the high percentage of Muslims in Nigeria.
In a way, yes. And also, even from the beginning of the negotiation of the constitution itself, it's just like saying not everybody even subscribe to customary law, for example. But customary law is part of Nigeria's legal system, whether anybody likes it or not. The only issue is that some customary law, because of the human rights movement, that have gotten to the high courts, I mean the Supreme Court and all, and they've been able to kind of balance some laws that need some balancing. But that is not part of Nigeria's legal system, is out of the table. So I think Nigeria just tried to accommodate from the beginning to accommodate that. We can't take this away. And I think also the people, the Muslim community must have really done a very good job in actually making their voice, part of the system, to know that, and for the system to also know that no, in this we have our own system of law. In fact, it's so entrenched that apart from even Islamic personal law, even to criminal law, like, is that entrenched? Even to criminal law, we have Sharia law. Some states that feel they prefer the Sharia, and the constitution allows them to do that. So it's a thing that I think it was negotiated and they've foreseen, and I think the Muslim community really must really have been part of that negotiation for it to really, even now it really jumped on me that they must really have been part of this, because for South Africa 2022, just recognizing Islamic marriage, I found it very, very weird. Like, and there are Muslims that subscribe to the Islamic marriage. And the reason why I raised the issue that in Africa, there are actually examples of that legal pluralism indeed. And Islam even came before the colonial masters even came. So Islam had even been part of the tradition of the people before the colonialism thing came. So it's a thing that is so hard for them to even have removed from the fabric of the nation.
Just got a question at the back.
I think it's a question starting from the previous question. So let's say now the parties that the ones affected on the in terms of like that have opposed the Hybrid court, they now have a problem again. Maybe they're dissatisfied by the judgment. Do they go to the apex court to hear the matter, or they still an apex court for Iceland, like for Iceland marriages, for example?
So the court system has that hierarchy. So it's just that at the first instance, for such issue of Islamic personal law, just give the opportunity to, people that are grounded in that area to be the one to hear and determine the issue. And from there, it's been appealed. So we have the Sharia Court of Appeal as in provided in the Constitution.
With the apex court.
That's not even the apex court. So the Sharia Court of Appeal is it's the appellate court, and it also serves as supervisory. So whatever is coming from that, the Sharia Court of Appeal is actually composed of judges grounded in Islamic law and also the conventional, the common law system. They have both, because part of their qualification in constitution is that they have to be grounded, they have to have qualification in Islamic law and the common law system. So it gets there, and because of their experience and everything, they will look at it. So which is one of the reasons I'm advocating this, that if someone grounded in both systems deals with an issue, the reasoning, of course, and the person will do, I believe, the person will do better justice than someone just that knows only common law and knows nothing about. And Islamic law is not even something you just read in a day and say you've known it. No, Because people have even been studying it for years, they don't even understand some parts, they are still reading it. So it's something that you have to, really, really know. You have to know the depth, everything about it before you can even say you want to apply it. So, and from the Sharia Court of Appeal, then the Supreme Court, then that's it.
Okay, just got a question. We've got two more questions only. The person in the jacket, and then Ms. Safadin, the last question. We get
Okay, beautiful. This is very beautiful. I must say. My question is, in South Africa, and there's already a hierarchy that we can all see. And looking at section 8, subsection 3AB of the Constitution, how are we going to, do you maybe have recommendations on maybe how the framework can come and maybe work in South Africa, because it also applies to the TZA? Because I think the Traditional Courts Act and the RCMA as examples have already showed that the pluralism in South Africa is not necessarily pluralism. So if you go about with and suggest an Islam Act, for example, for recognizing marriages, it will be just by the way, and it might be the same result of the RCMA. So what kind of framework are you proposing? And also consider the fact that the legislature is people that are politicians and do not have the background or whatever. Even the drafting part of policy is not with the people that actually even understood RCMA at that, the customer law at that point. How we're going to avoid that when it comes to Islam in the context of South Africa.
Okay. With regard to the proposal, so I'm trying to look for the section I saw in South African Constitution that actually gives the Parliament the power to create courts. So additional courts can actually be created.
The Traditional Courts Act is already there, but then it's useless for traditions. For customary law, it's there. But then here's the thing, they serve mostly as an advisor. They can give an opinion sometimes, but then you look at section 8, it actually imposes that the development of law must be in a way of common law type of a thing. So how are we going to avoid the by the way as well when it comes to Islamic? Because there's already there, an example is there, but then it's not working.
Yeah, which is why I think I mentioned that it's very important, this thing can only be resolved neatly by the legislature. Is the Parliament that can do it, and it's going to take a lot of advocacy, a lot of a lot of engagement with them for them to really see why this is important. So because at the end of the day, it's just to make the law, and because it is the legislation, and they have the power to make that legislation, and it's through engagement with them. It's an intense engagement. I'm not saying it's going to happen maybe tomorrow, but it's possible. It's very possible.
Which is the final question, Ms. Safadin?
Thank you, Dr. I just wanted to ask with regards, I think you mentioned that in Nigeria, the school of thought they adopted in those Islamic court is the Maliki school. So I just wanted to ask whether if you get a couple or an individual follows a different school of thought, do the judges adopt to that? Yeah.
Okay. Yeah. So that act is just in Abuja, and because of the flexibility. So even if they do not adopt that school of thought, there is that flexibility in applying the one that applies to the parties, and that's even just one out of so many laws in Nigeria that states legislatures enacted in respect to Islamic constitutional law, especially in regard to marriage.
Okay, thank you. I would like to just say thank you very much for flying all the way in from Johannesburg, University of Pretoria, and flying out from Nottingham.
Yeah.
So thank you very much for gracing us by being here. We really do appreciate it.
Yeah.
Thank you very much. Ladies and gentlemen and attendees, I think we've come to the end of our inaugural symposium, and I would like to call to the front Seehaam Samaai firstly, and Dr Shaykh